senior citizen in the ex-serviceman, military.
ಕೇಳಿ
ಮಲೋಡ್ ಅವರಿಗೆ ಕೊಡ್ತೇನೆ ಅಂತ ಗ್ರಾಂಟ್ಗೆ ಕೊಡ್ತೇವೆ ಅಂತ ಹೇಳ್ಕೊಂಡಿದ್ರು.
ನಿಮಗೆ ನಾಳೆ ಬೇಕಾ? ನಾಳೆ
ಯಾವತ್ತು ನೆಕ್ಸ್ಟ್ ಡೇ ಅಂತ
ಮೆಮೊ ಕೊಟ್ಬಿಡಿ.
Yes.
Until it is 2:30, don't move me.
ಇಲ್ಲ ತೊಂದರೆ ಇಲ್ಲ.
For adjournments, page number 11, seal number 51 to 54. Page number 12, seal number 55 to 57. Page number 13, seal number 58 to 61. Page number 14, seal number 62 and 63. For preliminary hearing, seal number 1.
Lordships, kindly, my lords. Serial number 38, my lords. I appear for the respondent number 2. I'm filing a NOC Wakalat today. I need.
Please wait. Hearing on IA, don't move. Please wait.
I have only filed a.
Hearing on IA, move over. Please wait.
Seal number 1, Shri Nataraj Ballard.
I seek for 1 week time, my lord.
What is the matter about?
Preliminary hearing. Lordship, 1 week, my lordship. I will.
Tomorrow.
Seal number 2, Shri Chokka Reddy.
In bogus entries. CJ takes notice for response 120.
Seal number 3, Shri Akshay Kumar Jain.
May it please. Petitioners counsel, madam. My lord, the grant is of the year 2013. Page grant is of the year 2013. Annexure A is the proceed notice, my lords. The notice, kindly beg to read, my lord, the notice. Notice says under 108K, ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಚಾರಣೆಯು ಸ್ವಯಂಸೋ ಅಂದು ಕೋರ್ಟ್ ಹಾಲ್ ಡ್ಯಾಶ್ ಎಲೆಕ್ಷನ್ ಕಮಿಷನರ್ ಇದ್ದು ದಿನಾಂಕದ ನೀವು ಸ್ವತಃ ನ್ಯಾಯಾಧಿಗಳ ಮುಖಾಂತರ ಹಾಜರಾಗತಕ್ಕದ್ದು. My lord, you are given to understand the proceeding is initiated by the clerk sides for cancellation of the grant. Nothing is stated. You ಹಾಜರಾಗತಕ್ಕದ್ದು. There should be a proper show cause notice also, my lords. Nothing is stated. This is all that is stated.
What is wrong? Go there and then they'll give you a notice.
And my lords, what they have done is, my lords, kindly see, we have gone there, page 15. And our advocate went and time for objection anta hogide page 15 alli. My lords, they should indicate, my lord, what is the purpose of that.
What is the intent, madam, of this proceeding?
Cancellation of grant under 108K, my lord.
They should say, my lord, we have intent to cancel it. And
Record is
my lord, 108 ಹೌದು ಅವರು ಶೋಕಾಸ್ ನೋಟಿಸ್ ಅಲ್ಲಿ ಶೋಕಾಸ್ ನೋಟಿಸ್ should indicate it, my lords, and without that
You only want a formal show cause notice.
no, my lord, the one aspect is that, my lords. Second is 2013 grant. Now in 2024 they say we want to
What is the basis for the show cause notice?
the grant.
No, what is the basis? Are they saying that it's a bogus grant? What is their allegation?
No, they have not made any allegation now presently.
Give him a notice.
Coffee plantation, my lord. For Form 57, coffee plantation cannot be granted, my lord. That's why it has been, notice came to be issued by the AC under 108K.
No, I'll dispose it of
cancellation.
directing you to furnish a copy of the show cause.
ಅಲ್ಲ ಅವ್ರು ರೆಡಿ ಮಾಡಿಲ್ಲ, ಇನ್ನು ರೆಡಿ ಮಾಡ್ಬೇಕಷ್ಟೇ. ತಾವು ಹೇಳಿದ್ಮೇಲೆ ಆರ್ಡರ್ ಕೊಟ್ಟ ಮೇಲೆ ರೆಡಿ ಮಾಡ್ತಾರೆ.
ಮಾಡ್ತೀರಿ ಬಿಡಿ, ನಿಮ್ಗೆ
ಹೌದು,
reply
ರೆಡಿ ಮಾಡಿ ಫ್ರೆಶ್ ಆಗಿ ಇಶ್ಯೂ ಮಾಡಿ ಸ್ವಾಮಿ. ರೆಡಿ ಮಾಡ್ಲಿ ಪ್ರಾಪರ್ ಶೋಕಾಸ್ ನೋಟಿಸ್.
My lord, 108K itself
No,
for cancellation.
you want details, even details, and then consider the matter afresh. Let the proceedings be pending. I'll only direct you to issue a proper show cause notice, giving the details as to why the proceedings are initiated. Let him give a reply and then the proceedings can go on.
Yes, sir.
The petition is directed against the proceedings initiated by the Assistant Commissioner. So it is the contention of the petitioner that the proceedings have been initiated without any show cause notice, and the petitioner is basically unaware as to why the proceedings have been initiated. And AGA on the other hand submits that the proceedings initiated is under section 108 capital K of the Land Revenue Rules, which pertains to cancellation of the grant. In the light of these submissions, the Tahsildar, the Assistant Commissioner is directed to furnish a notice to the petitioner intimating the reason for which the proceedings are taken up against the petitioner, so as to enable the petitioner to file his objections to the same. Such a notice shall be given by the Assistant Commissioner within a period of 3 weeks from today, and the petitioner is granted 3 weeks time thereafter to file his objections. The proceedings shall thereafter continue as per next A and B, petition according disposed of. 3 weeks, they'll give you a notice, you give a reply, and then
Please, my lords.
Timer can be fixed for reply also.
3
Okay,
weeks.
then.
For
3 and 3.
Till number 4.
Great, my lords.
In this case, I am for the petitioner, my lord. The petitioner's father was in a unauthorized cultivation of the land bearing survey number 50.
Madam?
So representation were given, my lord, they have not considered so far.
Where's your form number 50?
It was issued in the year 2019.
Where is the form?
That is situated at Madnaiknalli village,
Lala. Where's your form? Form 50 illide.
Form 50. The Form
Produce
50
ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
No, without there being a form.
Grant ಇದೆ, ಸಾಗುವಳಿ ಚೀಟ್ ಇದೆ, annexure A. Even typed copy is there.
Then what are you seeking for? You already have a Sagwadi check.
Is continuously in the possession, my lord.
For computerized entry. As and when
Only
the-
computerized mail. Already MR has been ordered and issued. The manual copy.
Consider ಮಾಡ್ತೀರಾ?
After verifying the genuinity of the grant, we will consider as per law. Because as per my information, no 50 applications are pending consideration before any of the land grant.
No, but he appears to be saying that he's already got a grant.
ಅಲ್ಲ, already.
That's why this grant is genuine or not, it has to be
Let them
verified,
consider everything. The parents
including the
petition
genuinity of this grant.
is
We
for
will
issuance
consider.
of direction to respondents 2 to 5 to consider the representations dated 28/8/2019, 21/6/2022, and 28/1/2024. Copies of which are produced as Annexure H, J, K, and L respectively. By these representations, the petitioner is requesting for registration of his name as the Khatedar on the premise that land has been granted to him under Annexure A. In the light of the fact that the petitioner claims that there is a grant made in his favor, it will be appropriate to direct the respondent, the fourth
Land grant
respondent,
committee, my lord.
fourth respondent,
Yes, madam. Fourth.
the fourth respondent to consider the claim of the petitioner and pass appropriate orders in accordance with law. It is made clear that nothing mentioned in this order shall be construed as an opinion rendered on the merits of the claim of the petitioner. And the Tahsildar shall examine whether the petitioner is the beneficiary of a grant and whether the Khata is liable to be registered in his name on that behalf. The Tahsildar granted 3 months time to undertake and complete the exercise.
Till number 5, Shri Shiv Kumar V.
ಏನಾಗಿದೆ? Vijay takes notice for respondents.
Till number,
We list.
till number 6, Shri Vishwanath Shetty.
Consider the representation writ of Mandamus by that Annexure J1 mail.
J1.
J1 mail, 103. Page number.
Pages,
Petition, huh?
page.
Page 103.
Where is the WP 12998? Where is the earlier order?
39 WP ನಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ
ಎಲ್ಲಿದೆ
ಅದಕ್ಕೆ
WP
ಮುಂಚೆ
copy ಇಲ್ವಾ?
WP ನಂಬರ್ 98 annexure J, my lord.
Annexure J is a representation in which a reference is made, WP 12998.
ಹೌದು ಸ್ವಾಮಿ, ಅದು ರೆಫರೆನ್ಸ್ ಹಾಕಿದ್ದೀವಿ ಸ್ವಾಮಿ. annexure J,
Annexure?
J 98 ಪೇಜ್ ನಂಬರ್. ಅದರಲ್ಲಿ accordingly writ petition stands dismissed with liberty to file petitioner to approach the concerned authority within period 8 weeks from the date of the receipt of this order in the event of making representation.
That they have considered it or not, because that petition came to dispose of in the year 2020 itself.
And accepts notice for respondents. 6/4. Temporary security instructions. ಯಾವ್ದು
10 days.
list on.
Twelve. Seal number 7, Shri Ajit PV.
My lords, I am challenging the endorsement issued by the Tahsildar Chikmagalur, respondent number 1, which is at page 40, my lords. Lords, they say that the land which was granted by the very same Tahsildar, I have produced the grant certificate at page 32. It says that land comes within the city limits, that is the radius of
Where is the grant order?
grant order is at page 32.
Two 2018.
2018 grant.
ಏನ್ ಮೇಡಮ್?
And my lords, in the same survey number, the land which was granted to others, in favor of them, the RTCs and MRs have been mutated. I have produced at page 41, my lords.
While registering the Kata, can you sit on judgment over the grant?
Yeah, my lord, this falls within the jurisdiction of 5-kilometer radius.
No, but how can he sit in judgment over the grant? Until the grant is cancelled, he is bound to register the Kata, isn't it?
My lords, may I,
That's why 108K,
Notice issue ಮಾಡಿರಲ್ಲ ಇದ್ರ.
may I take my lords to,
Wait.
this proceedings has to be initiated for cancellation of grant. But we don't know whether.
ಇಲ್ಲ,
this grant is-
2018 ಅಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ, ಇವಾಗ ನೀವು ಅವ್ರ ಖಾತೆ ಕೇಳಿದ ತಕ್ಷಣ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದೀನಿ ಗ್ರಾಂಟ್ ಅಂದ್ರೆ.
Yes, my lord, I'll secure instructions, my lord,
Alla,
whether it has been cancelled or not. I have
Alla,
He also says that the same survey number, Kata is registered in favor of similarly placed grantee.
I'll verify, my lord.
my lords, 27 ಅಲ್ಲಿ ಅವರೇ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ. Kindly come to page 27. A report filed by,
Now reconsider keeping in mind that you already accepted the grant instead of similarly situated lands.
That's my apprehension is that whether this grant is made in.
No, he does not doubt the grant. The Tahsildar does not doubt the grant.
Yes, ma'am.
He is saying that the grant is bad because it's within 5 kilometers. Can the Tahsildar say that after the assistant commissioner or the deputy commissioner grants a land?
I had to verify whether 108K proceedings have been initiated or not. I had to verify.
They have to,
I'll secure instructions.
they have to do.
Yes, sir.
Seal number 8, Shri Abdul Mariappa.
Petition on my lord. The land was granted in the year 97, my lord. Thereafter gave the number of representation to respect of the Kata and mutation register. That's why the petition before your lordship for the Mandamus.
Relist.
7.
PG accepts notice for respondents.
Seal number 9, Shri for the petitioner, 16 December 1965, Sagulich it was issued. Now the subject impugn proceedings is, my lords, the AC has dismissed my appeal for default for non-prosecution.
ಏನ್ ಮೇಡಮ್?
Prior to this, my lords, it was earlier also it was dismissed. And the special DC at page number 70,
ಗೈರಾಜರಾಗುತ್ತಿತ್ತು. 2004,
Yes,
2004,
you filed the petition in 2024.
that's right, my lords. My lords, page 70 is the, my lords, special DC reminds the matter to accord
But-
fresh opportunity.
Here's what is the reason?
His father was prosecuting the matter. He passed away.
Decades.
Also, my lords, I have filed an
What is the
application.
proceeding initiated for?
136, my lords, the respondent number 5 claims that he is in possession of the land. I have got a sago licit and I'm in possession. The only, my lords,
We don't know what has happened there afterwards.
lords, also
They're also there, my lord. They want.
only one respondent is there. And my lords,
Suppose he has sold the lands. The khata is in his name.
yes, my lords,
For the past 20 years,
yes.
he would have pursued the footing that he has become the absolute owner.
No, my lords, but he
What is your claim for a change of khata?
pursuant to the grant made in favor of my father, survey number 5, he claims, my lords, that he is in possession of survey number 5, but it is survey number, I'm sorry, survey number 5/9 is my land. He claims the very same land, but it is not so.
Go to the civil court. Why do you want to fight with the khata?
Only, my lords, I'll take your lordships to page 70 special DC. Set aside I understand what your lordships are saying.
I don't know what has transpired, and he would be under the impression that he has succeeded. Now, after 20 years, if you want to shake the boat,
It is an appealable order, madam. 136 really AC dismissed for non-prosecution.
ಅದೇ
They
ಹಾಕಿದ್ದೀನಿ.
could have approached DC for immediately for restoration of order.
ಅಲ್ಲೂ ಇದೆ ಆಗತ್ತಲ್ಲ.
ಅದು So not to save limitation.
ಅಲ್ಲ ಆಫೀಸು, I'm not on record, my lords, what it shows. Kindly see the typed copy at page 27. Presiding officer is engaged, otherwise hence case was adjourned was several number of times.
I would have,
Ultimately,
without asking her, I would have allowed the writ petition. But after 20 years, I'm not prepared to go to the civil court and agitate your rights. This writ petition is filed challenging an order by which the Assistant Commissioner has dismissed the appeal filed by the petitioner for non-prosecution. Though in the normal circumstances, the order would be set aside and the matter would be remanded for consideration of merits. In regard to the fact that the order of dismissal for non-prosecution was passed in the year 2004. It is nearly 21 years ago. In my view, it would not be appropriate to retain this writ petition. The petition is therefore dismissed. Our liberty is reserved to the petitioner to approach the civil court if he were to contend that there are rival claims being made on his land and the mutation made respect of his land is incorrect, subject to the liberty granted above. Writ petition is not cost.
great.
Take notes only 1 to 4. Sorry.
AJ accepts.
5 is the
Correspondence
private.
Seal number 10, Shri Divakar Singh. Shri Divakar Singh. Seven. Seal number 11. Shri Naik.
Hey, beg to appear for petition.
In
In this case, my lord, Kumki land has been sought for committee. Committee has recommended to grant the Kumki land, my lord, belongs to the petitioner who is cultivating the land, adjacent to the land who has purchased the land in question. The
Next, your deed.
Tahsildar made report to the Assistant Commissioner stating that as if the committee is not having a right to grant. Therefore, it was cancelled and subsequently I have filed review petition, my lord. Review petition was rejected. Therefore, I am before this honorable.
This comes within 5 kilometers of the municipality, then.
Yes, 5 kilometer radius.
Then how can they grant Kumki privilege to you?
Grant has been made by the committee, my lord.
ಅಲ್ಲ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗತ್ತೆ if it's within 5 kilometers?
ಅದಕ್ಕೆ ಕಮಿಟಿಗೆ ಜೂರಿಡಿಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ತಹಸೀಲ್ದಾರು ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾರೆ ಸ್ವಾಮಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ಗೆ.
Grant order
ಅಸಿಸ್ಟೆಂಟ್
ಆಯ್ತಾ?
ಕಮಿಷನರ್ ಹ್ಯಾಸ್ ರಿಮೈಂಡೆಡ್ ದ ಮ್ಯಾಟರ್ and that order I have questioned before the review authority, revision authority. Revision authority rejected my revision petition.
ಹೇಳಿ ಹೆಂಗೆ how can that be granted to you within 5 kilometers?
Like, because it is not within the, my lord, the application which was filed long back, not now.
When did you file long back?
ಅಂದ್ರೆ ಮುನ್ಸಿಪಾಲಿಟಿ ಈಗ ಎಸ್ಟಾಬ್ಲಿಷ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಈಗ ಮುನ್ಸಿಪಾಲಿಟಿ ತಗೋತಾ ಇದ್ದಾರೆ ಅವರು. ಬಟ್ ವಾಟ್ ಎವರ್ ಅಪ್ಲಿಕೇಶನ್ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಟ್ ಹ್ಯಾಸ್ ಟು ಕನ್ಸಿಡರ್ ಮೈ ಲಾರ್ಡ್,
When did you
ವೆದರ್
make
ಇಟ್
the
ಈಸ್ ಕಮ್ಸ್
application?
ವಿದಿನ್ ದ 5 kilometer or not.
When did you make the application?
Application
2018 itself.
87/2002, my lord. Because on that I registered and immediately I have made an application.
AC has remanded the matter to.
It is a Kumki land, my lord.
ನಾ 2018 ಅವಾಗ್ಲೂ ಇತ್ತಲ್ಲ.
ಅವಾಗ ಅದು ಮುನ್ಸಿಪಾಲಿಟಿ ಅವಾಗ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ರೀಸೆಂಟ್ ಆಗಿ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ದಾರೆ.
ನೋಡಿ ಮೇಡಮ್, ಚೆಕ್ ಮಾಡಿ.
My lord, it is remanded matter, my lord.
No, DC
DC
order.
also, my lord, DC also uphold the AC's order, my lord.
AC's remand order is confirmed.
Yes, my lord.
ಬಿಡಿ ಹಂಗಾರೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಬಿಡಿ.
Yes, page number 18, my lord.
ಇಲ್ಲ, ರಿಮೈಂಡ್ ಆರ್ಡರ್ ಅಷ್ಟೇ ತಾನೆ ಇವಾಗ.
ಹೌದೌದು.
ಮತ್ತೆ ಬಿಡಿ, ತಪ್ಪೇನಾಗುತ್ತೆ?
ಅಲ್ಲ, ರಿವಿಷನ್ ನಾವು ಹಾಕೊಂಡಿದ್ದೀವಿ. ರಿವಿಷನ್ ಪಿಟಿಷನರ್ is also considered, my lord, because I am not a party to the said proceeding, my lord.
Proceedings were initiated under section 108K of
While remanding the matter, my lord, I am not a party.
which led to an order passed by the Assistant Commissioner on 1st of October 2020, by which the Assistant Commissioner remanded the matter for to the Tahsildar for reconsideration. This order of remand was challenged by way of revision to the Deputy Commissioner, and the said revision has been dismissed. In my view, since the Assistant Commissioner has only remanded the matter for reconsideration, the same has found favor of the Deputy Commissioner. In my view, there is no justification for entertaining this petition. Article 226. Petition is therefore dismissed.
1 to 4, I'll take.
AG accepts notice.
Please. Number 12, Shri Sumant Kumar Patil.
Prepared for the petitioner's counsel. Entries stand in the name of the petitioner and his predecessors right from 1958 onwards. Without a mutation or any order or notice, entry was changed to Sarkara. Then I pointed out it is of my ancestral property, the entry has to be restored. Now they say it's a forest land. Therefore, it could be only privileges that could have been granted to you. I'm not asking for grant. Entries which are there from 1958. Kindly see first of the entry that I have produced at page 18.
What is the order that you're challenging?
The endorsement says that it is only privilege that should be entered in your name, not as owner.
What is your right?
It's my ancestral property. Right from 1958 in column number 9, column number 11, column number 12, my name appears.
It's not notified under the notification.
No, it is not notified.
In madam?
Ultimately, even if it is notified, there is no question of their changing the entry and doing it without notice to me.
Madam?
My lord, this is Sarkari Kanu. That's why.
No, is it a notified forest?
Yes, my lord. That is what
Is
the
it
endorsement says. My lord.
Where is the notification?
I'll secure, my lord. The endorsement says that
Actually-
because of it is Sarkari Kanu, they cannot claim ownership.
No, but there must be a basis for it. If his entry is there from 1958 for nearly 50 years,
Yes, my lord.
once one fine day you can't say it's forest.
Then I'll produce all the details necessary.
AG accepts notice for respondents. Released on so. Until then, both the parties to maintain status.
Number 13, Shri Fayaz sir.
We are for petitioner in this case, Lord. Lord, in this case, the petitioner purchased the property under registered sale deed dated 15/10/1976, Lord. Thereafter, Lord, the revenue records have been changed in my name. Then because from a portion of my land has been acquired by the land acquisition officer for Ethinawale project. To assess my compensation, Lord, this Ethinawale project has directed me to get the separate sub number to my property. For that, I applied for that, Lord, that instead of assigning and podium, Lord, this respondent number 4 has been issued the endorsement annexure K, page 49, Lord. Referring the another WP number, what happened, Lord, in the earlier, this petitioner sold this property to the respondent. Again, they are changed the revenue records in their name. Even though after selling this property, that I initiated the proceeding before the Assistant Commissioner, Deputy Commissioner. Thereafter, this court has passed the order. Once the property has been sold, the same person, he cannot change the revenue records in his name. For that, the interim order has been granted.
Pending idea.
Pending this.
Post along with WP 7745.
7745 of 21.
AG accepts notice for respondents.
Date may be given because for that.
Released on.
Seal number 14, she.
Date.
Fourteen.
I appear for this question.
Petitioner's mother purchased the land in year 1968. In 91-92, her name was entered. At that time, computerizing,
She had purchased 91.
that 91, it was entered. That thereafter, computerized point is, that her name has been left out. That in respect of the remaining portion of the 19 guntas of land, it stands in the name of me, because I have purchased in the property in the 1992. That 91, that remaining 19 guntas, it is an old J form. Therefore, it is not indicated. Therefore, I am not, it is not proper to effect the
In
mutation.
whose name is it standing now?
That it stands in the name of my vendor. That they are not objecting. They, one of the legal aid has held.
There's a
That-
registered sell it from the Katedar. Page? No, he says he is a purchaser. No, if the person registered sale it, it's your duty to get it changed. How can you shift the burden on them? No, they should not even approach you, isn't it? It's your responsibility. No, if what he says is correct and the Kata stands the name of his vendor, if there's a sale, it's got to be changed, isn't it? AJ accepts notice for respondents. Vendor no party madidara?
The vendors are also party. Why? That respondent has filed an affidavit before the assistant commissioner.
Show notice to R5. On lawyer need see.
Please, ma'am.
R5 on lawyer need see.
Please, ma'am.
5 to 8. Notice to R5 got it.
Seal number 15, Srimati Rachita.
Petitioners, counsel, my lord, sir. Cancellation of the grant, the Sagoli cheat, its grant is 2013, Sagoli cheat is 2016. Proceedings is initiated by 24 and it has been cancelled.
When was the land granted to you?
2013 grant, my lord, 2016 is the Sagoli cheat. 2024 it's cancelled. And the
Why is it cancelled?
cancelled is, my lords, one ground is earlier application was filed, it is kept vide idalagide anta ittu. Adu idru saita puna cancel to grant ಮಾಡಿದ್ರು.
Only, that's the only ground?
That first ground, my lords. Second ground is, one ground is that, my lords. Second ground, they say, my lords, the earlier proceedings of grant, it does not contain the signature of the Tahsildar, contains signature of other members only, not of the Tahsildar. Therefore, the grant itself should not have been granted. Third, amount is paid 2016 itself. They should not have received the amount in 2016. These are the grounds, my lords.
They have not been granted with the land. That is the reason given by the assistant commissioner, my lord. It is at page 30.
Page?
Page 30, my lord. ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಈ ಮೇಲ್ಕಂಡ ಅಂಶ ಅಕ್ರಮವಾಗಿ ಖಾತೆ ದಾಖಲಾಗಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. 53ನೇ ಅರ್ಜಿಯು ತಿರಸ್ಕೃತಗೊಂಡ ನಂತರವೂ ಪುನಃ ಅದೇ ಅರ್ಜಿಯ ಮೇಲೆ ಯಾವುದೇ ಆದೇಶ ಪಡೆಯದೆ ಮಂಜೂರಿ ಕಡತ ರಚನೆ ಮಾಡಿ
No, if it is rejected,
Kindly see the reasoning is page number 27, my lords.
no, is it rejected?
Kindly see, my lords, page 27.
Yes.
Thereon, they have contradictory statements, my lords. MR ಮೇಲ್ಗಡೆ first line. So and so ತಹಶೀಲ್ದಾರ್ ಹಾಜರುಪಡಿಸಿದ ನಮೂನೆ 53 ಅರ್ಜಿ ವಹಿ ದಾಖಲಿಸಲಾಗಿ ಸದ್ರಿ 631-98-90ರಲ್ಲಿ HM so and so ಪಿಟಿಷನರ್ ಹಾದಿ ಓಣಿ ಗ್ರಾಮ 2 ಎಕರೆಗೆ ಸಕ್ರಮ ನಮೂದು ದಾಖಲಿಸಿದ್ದು 5/6/2000 ಅಧಿಸೂಚನೆ ವಿಲೆ ಇಡಲಾಗಿದೆ ಎಂದು ಶರ ನಮೂದಾಗಿ ಕಂಡು ಬರುತ್ತದೆ. ವಿಲೆ
Page 30. This specifically says, ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಈ ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಅನ್ವಯ
ಹೌದು.
ಅಕ್ರಮವಾಗಿ ಖಾತೆ ದಾಖಲಾಗಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ.
ತಿರಸ್ಕೃತ ಆಗಿದೆ.
ಮುಂದುವರೆದು ನಮೂನೆ 53 ಅರ್ಜಿಯ ತಿರಸ್ಕೃತಗೊಂಡ
Please.
ನಂತರವೂ
Please, my lord, page 27, my lords, first para, last line, ವಿಲೆ ಇಡಲಾಗಿದೆ.
ಮೇಡಮ್ ರಿಜೆಕ್ಟ್ ಆಗಿಲ್ಲ ಬರೀ
I beg to read page 27 for a moment, my lords.
They have.
They have two stands. Page 27, second para, ವಿಲೆ ಇಡಲಾಗಿದೆ.
show me the order of rejection, then I'll dismiss the petition.
Yes, I'll secure it.
What he says is right, it is only disposed of without there being a specific rejection.
I'll secure records.
AG accepts notice for respondents. He is right to secure records which indicate that the form number 53 which had been filed by the petitioner was indeed rejected and the same had not been challenged as indicated in the impugn order. List on
Till then, my lords, your lords may kindly stay the impugn order.
both the parties to maintain status quo.
Grateful.
Seal number 16, Shivagondappa Zulfi.
Petitioner, and for the respondent. Blood, in the writ petition blood, as per annexure B. Blood,
What is annexure A?
annexure is the order of the deputy commissioner blood. And blood, annexure B. On 22/4/1999 blood, my brothers and myself have made a partition between ourselves. As per partition blood, the disputed property falls in my name. But kindly see next annexure C,
Registered partition illa.
oral partition blood. And as per, please, as per partition blood, as per annexure C, mutation entry made in my name.
When?
MR number 99/2000 blood. Annexure C blood. Thereafter blood, annexure D, without knowledge to me and without intimating to me, the annexure D mutation is created by my brother. It's a created mutation. Then blood approach the assistant commissioner blood, the assistant commissioner allowed the appeal in my favor. Your Honor, kindly see, blood,
This
kindly,
annexure C was after notice to you and to them?
no blood. I have not issued, blood, kindly see,
Annexure C,
annexure C is my mutation.
correct. Was it after notice to them?
Yes, blood.
They participated?
Yes, blood, participate. Up notice to, they have also agreed. And blood, kindly see page number 52, order of the assistant commissioner. Page number 52, blood.
How do you justify this?
No, blood. I'm sorry.
Dates are relevant.
ಇಲ್ಲ, ನಂಗೆ ಇಷ್ಟು first ಹೇಳಿ.
ಅಲ್ಲಲ್ಲ, ಇದು dates ಗೊತ್ತಾಗುತ್ತೆ.
Already stays granted by this
See.
court, blood.
Come to annexure C. Both of you are claiming under the partition deed, isn't it?
No, thereafter so many things taken place, therefore I want to,
ನಾನು ಅದು ಇಸ್ಕೊಡ್ತೀನಿ. First annexure C ನೋಡಿ. Page 30.
yes, Lord. Yes, we are all
Yes.
parties, we are all parties.
ಇಲ್ಲ. ಇತರ ಹಕ್ಕುದಾರರು ತಮ್ಮ ಒಪ್ಪಿಗೆಯನ್ನು ನೀಡಿರುತ್ತಾರೆ.
ಅದೆಲ್ಲ correct ಇದೆ.
So this was on which date?
In the year 1999, Lord.
Then annexure D
Yes, Lord.
is also of the year 1999-2000.
ಇಲ್ಲ, 2001, 2002, Lord.
1999-2000 ಅಂತಾನೆ ಇದೆ.
ಇಲ್ಲ,
2001, 2002.
ಅದು MR 138, 14 of 2001, 2002.
ತಪ್ಪಾಕಿದ್ದಾರೆ.
No, without any document, without supporting document,
Lord, ಇದು ಸ್ವಲ್ಪ dates ಇದರಲ್ಲಿ ಬೇಕಾಗುತ್ತೆ.
annexure C,
The typing mistake, it's not 1999-2000.
2001, 2000.
Dates are
Page number 31, it's 31.
Dates are relevant.
I'll complete my submission. Kindly see. Thereafter, Lord, approach the assistant commissioner. Assistant commissioner is allowed the appeal. Your Honor, Lord, kindly see page number 52.
Let us see annexure D on what basis it was done.
There is no any document supporting document, Lord. That is a created one by the
That's stated as.
Lord, page number 52. May kindly see, Lord, please.
ನಿಮ್ಮ ಹೆಸರೇನು? ಪ್ರಭಾಕರ್.
ಹೌದು.
ಪ್ರಭಾಕರ್ ಬಿನ್ ನರಸಿಂಹನಾಯ್ಡು ಅವರು. This partition that is referred to in annexure D is the very same partition?
That is created by my brother without
Not the
knowledge.
same
to me.
partition.
No, Lord. That's why, Lord, the assistant commissioner observed, Lord, kindly see page number.
Whose
50.
name was the Kata standing before this?
My name, Lord.
Before annexure C and D?
My name, Lord.
Is it a fact?
Prabhakar.
Lord, ತಗೊಳ್ಳಿ.
Before
One-
annexure
one.
C and D?
Lord, so you are not.
But kindly see.
I have given. First, Lord, first mutation, Lord, so as they have said, Lord, mutation is taken place. thereafter, my lord, 22/11/2000, my lord, the petitioner is entered into a registered sale agreement with one Mr. Karim, my lord. My lord, thereafter, my lord, so Mujbane Parikat is entered 13/2/2002. My lord, thereafter, my lord, so this husband of the petitioner, my lord, has cleared the loan, the sale consideration to Mr. Karim. Therefore, my lord, that sale agreement came to be cancelled.
Both
There-
of them are Jubane.
Yes, my lord.
That is second partition in blood.
So Jubane, second.
Second one, ಅದು ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಅದು 15 years ನಾನ್ ಎಲಿನೇಷನ್
Where
ಪೀರಿಯಡ್.
is the registered agreement of sale? You
They
executed registered
blood,
agreement of
no
sale
Yes, they have executed.
on 22/11/2000.
Blood, I produced the additional document last date of hearing blood.
I have produced the documents also, the encumbrance certificate also. Along with the memo.
Additional document, page number 17, I produced previous statement.
Plus,
and the
there is
additional
there is a suit for declaration.
Additional documents I produced previous statement.
Which number?
Page number 17, blood. Additional document. Register ಕ್ರಿಯೆಯಾದ ಕರಾರಿನ ರದ್ದಿಯಾತಿ ಪತ್ರ.
Cancelled sale agreement.
Yes, blood. Which is what is stated, Karim Sami executed. That is a cancelled, blood. On very same day, blood. Next page, blood, kindly see at page number 21. Mujbane Vibhag Patra second did they have created this without my knowledge. This you say partition blood on 13/2/2022. That annexure D is created in the year 2021 itself, before 1 year blood. After creating
but
that,
You had agreed to sell the property.
no, blood.
Yes.
Why was it cancelled?
Blood,
By way of registered instrument?
all the family members, myself and my brothers have paid the amount. And that cancelled the
It is a cancellation of the registered agreement.
blood. What happened, blood? As per partition, blood, I agreed to pay 77,000 rupees. And but I paid the entire amount. And all the family members again,
Cancellation of the sale agreement, where is that?
cancellation of sale agreement, blood, page number 217. On 13/2/2022.
Husband of the respondent poor is also party, my lord, Sambasiva.
No, this is an agreement in execute in favor of Narayanam.
Yes, blood.
Who's Narayanam?
My mother, blood.
Your mother.
Yes, blood.
So the partition was in favor of whom?
Myself, in the year, as per annexure B.
No, if it was in your favor,
Yes,
where
blood.
was the question of Narayanama's name coming up?
But Narayanamma, my mother and my brothers have executed partition deed. They have signed this property, dispute properties belongs to me as per partition deed.
No, under the partition,
Yes, blood.
it was fallen to Narayanama's share or to your share?
No, we have made a partition ourselves. The other properties followed to say my brother, that is in Punganur, Andhra Pradesh. This disputed properties followed to my share. Now, blood, after the partition,
Partition did that you referred to 99/2000.
yes, blood.
Under that partition, it was it given to your mother or to you?
All my family members have made partition ourselves.
ಈ ಪ್ರಾಪರ್ಟಿ ಮೂರ್ ಜನಕ್ಕೂ ಸೇರ್ಸ್ ಕೊಟ್ರ
ಇಲ್ಲ ನಮ್ಗೊಬ್ಬರಿಗೆ ಸ್ವಾಮಿ ನಮ್ಗೊಬ್ಬರಿಗೆ ಕೊಟ್ಟಿದ್ದು ಹೌದು ಆಸ್ ಪರ್ ದಟ್ ಬ್ಲಡ್ ಮಿಟೇಷನ್ ಎಂಟ್ರಿ ಮೇಡ್ ಇನ್ ಮೈ ಫೇವರ್.
Where is that fourth respondent is a party here?
My lord, ಅದರಲ್ಲಿ cancellation deed ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. I have produced the encumbrance certificate also.
Two 2002, you say that after this, there was another agreement.
Yes,
Blood.
blood,
And
no,
when was the kata changed after that?
2001, 2002, in my husband's name, my lords. Thereafter, my lord, in the year 2005, my lord, he is mortgaged the property in favor of the ING Vaishya Bank, 2005. Thereafter, my lord, Gramina Bank FD 3 occasions. After lapse of 23 years, my lord, they have challenged the mutation affected in my.
You mortgage the property.
Yes, my lord.
No,
2005.
blood, kindly see page number 10, blood, additional document, blood.
I produced
All the
dates
family
also.
members, blood, kindly see page number 10. On 24/2/1999, my brother has got the sale. Page number 11, kindly see, we have given another survey number 102, 1 acre 26 kuntas. He has sold that property. After sold, blood, he came to my property as per partition.
The fact that he had mortgaged his property twice.
Without my knowledge, blood, I am in Bangalore, blood, my brother is yearly giving crops to me and amount. Immediately after death of my brother, blood, my brother wife changed kata in her name without my knowledge. And without challenging my interpretation entry, Annexure C, that is in force. And Annexure D is created on what basis, not as per this Mujbani secondary partition.
Annexure D was after notice to you.
Yes.
No, blood, you are not participating, I have no knowledge about it.
So form number 21 is published.
I am in Bangalore. There is no any supporting document.
You
23
challenge
years
this
still.
2001, 2002 order.
Yes, but
24 I'll challenge. my lord.
there is no any supporting document created with revenue authorities. There is no any supporting document for Annexure D.
Any litigation in the civil court?
Yes.
No,
suit for
civil- I
declaration,
filed
they
suit
have
for,
filed
I have filed suit for
declaration,
recently.
that is pending.
In
Yes, Lord.
subject
No.
to that result.
What will happen, Lord, based on this mutation entry, they have entered into sale agreement. Brown kindly have produced that.
You are before the civil
Page,
court.
Yes,
page,
Get an interim order there.
yes, there are there.
And
is a
this
property
amount-
element there.
today my submission is, Lord, after order passed by this on last date. And Lord, kindly see, 17/2/2025, this honorable court has passed interim order. Interim order idru kuda revenue authorities who colleague agi ಅವ್ರ ಹೆಸರು ಖಾತೆ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು
In this writ petition, have you narrated that you had executed registered
Yes,
document of
Lord.
sale?
Lord, kindly
In this petition, have you indicated that you had agreed to sell this property and thereafter that agreement of sale was
No, no.
cancelled by another agreement of sale?
No, no.
No, Lord, I have not party to that. Without my knowledge, that only for,
You did not hear my question correctly.
please, Lord.
This writ petition,
Yes, Lord.
have you stated in your writ petition that you had executed a registered agreement of sale in favor of
No,
person?
so and so person, I have not executed, Lord. I have not executed sale agreement. During the cancellation sale agreement, I participated, I paid some amount also.
Have you mentioned that here in the writ petition?
Yes, Lord.
Where have you said so? Where have you said that?
Yes, Lord. Blood, page number 9, blood.
Page number?
9, page number 8, it starts from para number 3. It is submitted that original properties of the family Sri Narsim Naidu had 4 sons, that is Srinappa, Sri Samba Shiva, husband of petitioner of the respondent number 4. Prabhakar is myself, blood. The petitioner herein and Sri Bhaskar, upon death of Narsim Naidu, his wife Srimati Narayama and 4 sons entered into Mujbani partition dated 24/2/1999. As per the partition, said partition deed, the properties in question, that is survey number 103, but 2P1 measuring 3 acres and survey number 103 or P2 measuring 3 acres 15 gutas situated at Kadanelli village, Bairpur Hubli, Mulbagal Taluk, Kola district were allotted to petitioner herein. The partition deed dated 24/2/1990 is here produced Annexure B.
Where have you said about the agreement of sale and the cancellation?
Because, Lord, I have no knowledge about this agreement of sale.
You just now said that you had executed the agreement of sale and you had paid the sale consideration.
No, Lord,
ಈಗನೇ ಹೇಳಿದ್ರಲ್ರಿ.
cancellation ನಾನು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ದೀನಿ ನನ್ನ
Where have
ಅಗ್ರಿಮೆಂಟ್
you said that in the writ petition?
ಬಟ್ ಇದ್ರಲ್ಲಿ ನಾನು ಹೇಳಲೇ ಇಲ್ಲ ನಾನು ಕ್ಯಾನ್ಸಲೇಷನ್ ಬಗ್ಗೆ ಅಡಿಷನಲ್
Is
ಡಾಕ್ಯುಮೆಂಟ್
you're suppressing facts.
ನೋ ಬಟ್ ಐ ಆಮ್ ನಾಟ್
You should
ಸಪರೇಷನ್
have stated that behind my back, they entered an agreement of sale. I came to know about this.
No,
I
but-
got it cancelled.
after partition did not one Karib Savi you entered into agreement of sale. Blood
So
at the
what was it?
cancel kindly see blood.
Either way, you're in the civil court, isn't it? OS
Was
48
up to-
It's filed by me. What will happen, blood? Second partition Annexure D has created based on that mutation entry, blood.
establish that in the civil court.
I establish civil court, but what will happen, blood? Based on the entry, blood, they are going to alienate the property, even they have violated the order of this court.
You have an interim order or not in the civil court.
Yes,
Yes, blood.
not to illiterate on this.
Blood, kindly see, blood.
We are not challenging that order. Lord.
Don't disturb him in his argument. Please, you will lose his train of thought.
Blood, kindly see, blood. After passing, sir. What I'm submitting to your court, not kindly see. Order of this court, on 17/2/2025. This arm court has passed interim order. And on very same day, next on 19/4/2025, I intimated the Tahsildar and Deputy Commissioner. There is an order of this court. And even after interim order is there, they change the kata in their name. What is the personal interest with colliding revenue? That's not.
I want to know, why should I entertain the writ petition for a person who suppresses facts to this court, who does not indicate this was registered agreement of sale and that agreement of sale was cancelled? At your instance, why have you not mentioned all that?
Kindly see page number 52, that is Assistant Commissioner is observed, kindly see.
And question
Please, blood.
you have chosen to suppress facts.
No,
They are
blood.
material to this writ petition.
Blood, these additional documents after filing writ petition I got. Blood, before that, blood, I have no knowledge about that.
Your submissions are contrary to your earlier
No,
submissions.
blood, kindly
But
see,
clearly you told me now that the agreement of sale, you got cancelled by paying the amount.
cancellation of agreement, blood, my name is shown. That's why I'm submitting before this court. I'm not suppressing, blood, kindly observe.
You have
Kindly
not-
see,
you have not even whispered in your writ petition.
no, blood.
So
Why?
therefore,
Because, blood, after filing the writ petition, the additional document I got. In that cancellation did, blood, my name is shown.
Unless he had not
Blood,
filed
I'm
objections.
challenging only mutation entry boards, blood.
So I will only say, the order of mutation is subject to the ultimate result of the suit that you have filed.
ಅಲ್ಲಿವರೆಗೂ ಸ್ಟೇಟಸ್ ಕೊ ಮೆಂಟಾರ್ ಸಾಕು ಇವರು ಚೇಂಜ್ ಮಾಡ್ತಾ ಹೋಗ್ತಾರೆ
ನೀವು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಲ್ಲಿ ತಗೊಂಡ್ರೆ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. You can't get an
ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೊಟ್ಟರು ಚೇಂಜ್ ಮಾಡಿದ್ರು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕ್ಯಾರೆ ಮಾಡಲ್ಲ ತಹಸೀಲ್ದಾರ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ ಬ್ಲಡ್ ದೇ have entered to agreement of sale after getting the order by the deputy commissioner immediately.
What to do in the civil court?
Please, blood.
Was there-
Until that flood, the direct not to change it.
It is not in dispute that as against the order of mutation passed in favor of the fourth respondent, an appeal was preferred, which has been dismissed. Dismissed an appeal.
Assistant Commissioner, please allow my favor.
Assistant Commissioner is allowed, Deputy Commissioner is.
Against the order of mutation passed in favor of the fourth respondent, an appeal was preferred to the Assistant Commissioner, who allowed the appeal. As against the said order of the Assistant Commissioner, a revision was filed, and the said revision is allowed. And the order of the Assistant Commissioner is set aside. The Deputy Commissioner has allowed the revision principally on the ground that the petitioner had already instituted a suit in OS 48/2024, which was one for declaration and for injunction. In my view, since the petition is already before the civil court seeking for a declaration injunction, the order of the Deputy Commissioner cannot be found faulted. The petition is therefore dismissed. It is needless to state that if the petitioner succeeds in the suit that he has instituted, the revenue entries will change accordingly. The petition is accordingly dismissed subject to.
That recent entries may be directed to Tahsildar to.
You are not truthful to the court. I don't want to exercise discretion.
Please, please. ಅಲ್ಲ ಅವರು ಮ್ಯೂಟೇಷನ್ ಎಂಟ್ರಿ ಮೇಲೆ ಮತ್ತೆ ಚೇಂಜ್ ಮಾಡ್ಕೊತಾ ಹೋಗ್ತಾರೆ
ಮಾಡ್ಕೊಳ್ಳಿ ಬಿಡಿ, ಹೆಂಗಿರೋ ಸೂಟ್ ಇದೆಯಲ್ಲ.
ಸೂಟ್ ಈಗ ಅದ್ರ ಮೇಲೆ ಮತ್ತೆ ಬ್ಯಾಂಕ್ ಲೋನ್ ತಗೊಂಡು ಹೇಳ್ತಾರ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಲೋನ್ ತಗೊಳ್ತೀವಿ ಹಾಗೆ ಹೀಗೆ ಅಂತ.
ನೀವ್ ತಗೊಂಡ್ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅವ್ರು 2 ಸಲ ತಗೊಂಡ್ರು ಅಂತ. ನೀವು ಮಾರ್ಬಿಟ್ಟು 20 ವರ್ಷ ಊರ್ಗಡೆ ಹೋಗಿಲ್ಲ ನೀವು. ನೀವು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಾ,
annexed is created, blood, kindly
ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಾ, ಇಬ್ರಲ್ಲೂ ನ್ಯಾಯ ಇಲ್ಲ.
ಅಲ್ಲ ಆರ್ಟಿಸಿನ್ ಅನ್ನೆಸರಿ ಇದೆ ಆಫ್ಟರ್ ಮ್ಯೂಟೇಷನ್ ಆರ್ಟಿಸಿನ್ ಎಂಟ್ರಿ ಇನ್ ಮೈ ನೇಮ್, ಬ್ಲಡ್. ಅಲ್ಲ ಇವ್ರು ಏನ ಇದ್ರ ಮೇಲೆ ಮತ್ತೆ ಅವ್ರು ಲೋನ್ ತಗೊಂಡು ಹೋಗ್ತು ಮಲ್ಟಿಪಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗುತ್ತೆ. ಅಲ್ಲ ಒಂದು ತಹಸೀಲ್ದಾರ್ ಡೈರೆಕ್ಷನ್ ಅಟ್ಲೀಸ್ಟ್ ಏನು ಚೇಂಜ್ ಮಾಡಬಾರ್ದು, ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡಿ ಪ್ಲೀಸ್.
I am allowing a writ petition if I do that.
ಅಲ್ಲ
Yes, please.
ಅಟ್ಲೀಸ್ಟ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಮೇ ಬಿ.
Serial number 17, I for petitioner.
Noted.
But in this petition, license, the license,
ಏನ್ ಹೇಳ್ತಾರೆ
yes,
ಕೇಳಿಸ್ಕೊಂಡು.
please. And matter may be disposed with direction to the authority to consider my objections, my lord.
ಏನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಳ್ತಾರೆ?
Yes, please.
Tenth. Number 18.
Date may be given, my lord. They will evict the petitioners from the land.
Hearing for petitioners, your lordship. Petitioners are the owner of the property, your lordship.
What are you challenging? Annexure A, B, C.
Annexure A is the DC order, your lordship, based on alleged will executed by my uncle, the khata and mutation was transferred in the name of respondent number 4, your lordship. Respondent number 4 is a third party and the property is joint and ancestral property, your lordship. The will is disproved in 2 suits. Based on that will, the mutation and the RTC khata and khata was changed from my name to respondent number 4's name, your lordship.
Whose property is this? Your ancestral property?
Ancestral property, your
Who's the
lordship.
Khatedar?
Khatedar was one Karegowda, your lordship, my grandfather. Thereafter, my father and uncle had become the khata proper owners, your lordship. Thereafter, my uncle, it is alleged that by respondent number 4 that my uncle Venkata Rayappa had executed an alleged will in 1992. Based on that will, the Tahsildar has.
On your grandfather's death,
Yes,
was
your
the
lordship.
Khatha changed in the name of your father and your uncle?
Yes, your lordship.
Both of their names were there.
No, your lordship. In the name of my uncle, that is Venkata Rayappa.
Not in your name.
Not in my name, your lordship, because he was the eldest.
Your uncle is stated to execute a will in his favor.
Yes, your lordship, but he has died issueless, your lordship. And this will has been disproved in 2 civil suits.
Filed by? Who had filed the suit?
Filed by respondent number 4, your lordship.
He had himself filed the suit on the basis of the will.
Yes, your lordship.
And that suit is dismissed.
That suit is dismissed. 2 suits he has filed, and both the suits, the will is not proved in that suits. And now, based on that alleged will, your lordship, Tahsildar has changed the mutation and khata from my name to respondent number 4's
Despite the
favor.
dismissal of the suit.
Yes, your lordship. And he has upheld the will.
Whatever narrated by my learned friend is everything is contrary to the documents and the judgments of the civil courts, my lord.
Did you file
They are-
your claim is based on the will?
No, my lord. Already there is a suit pending in the OS number 52 of 1999 filed by the third petitioner here. That declaration suit by claiming he is an adopted son of the deceased Venkata
I
Rayappa.
wanted to know about your right. You are claiming under a will.
Yes,
The
my lord.
Khatedar was Venkatrayappa.
Yes, your
My lord.
lordship.
You are
He is-
claiming under the will.
No, not. The entire whatever the properties, my lord, it is self-acquired property of Venkata.
Correct. You are claiming under Venkatrayappa,
Yes, my lord.
under a will.
Under wills, my lord, that already wills has been determined in OS number 52 of 1990. They are not whispered in. the
There is
entire
also
writ
suit
petition.
for partition, your
That's
lordship.
why,
Suit is filed by the adopted son.
yeah, no. That suit filed by the third petitioner herein.
That is the adopted son.
No. Petitioner. Petitioner number 3
He
filed.
claimed to be the adopted son of Venkatrayappa,
Yes, my lord.
and that suit is dismissed.
No, your lordship.
That suit, declaratory suit has been dismissed by the court in OS number 52 of 1990. They are not stated in the writ petition, my lord.
In that suit,
Yes.
the will has been held to be proved.
Yes, my lord, will has been proved and the title of the whatever the petitioner before this honorable court already the honorable court held that it is not the giant family properties. It is.
Where is OS? Where
They
is
have
OS?
not filed any papers, my lord.
Your lordship,
File.
para number 5 of my writ petition,
No, they are
page
only
number
part of-
7.
We have a copy of the judgment, was 52/99.
There is a partition suit pending, your lordship. Partition suit was partly
Have the
decreed,
copy, my lord.
which I have challenged in RA, your lordship. Pending suit, a pending appeal of that, the khata has been
You see, right
changed.
when it says in was 52/99, there's
It
a
is
finding that
dismissed, your lordship. That is filed by petitioner.
in that suit, was this issue of the will also gone into by the civil court? And is there a finding that the will has been proved?
Will has not been proved in that, your lordship.
You have a copy of the judgment.
Have- The very testator himself stated that before in that suit, my lord.
Your lordship, petitioner number 1 has also.
An issue,
I issue already the pleadings are there in that case, my lord. The
there an issue regarding the will.
ಇಲ್ಲ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಸೂಟ್ ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು ಅದನ್ನ ಇಶ್ಯೂಸ್ ಫ್ರೇಮೇ ಮಾಡ್ಲಿಲ್ಲ ಬಿಕಾಸ್ ಆಫ್ ದಿ ಪಿಟಿಷನರ್ಸ್ ದೇ ಫೇಲ್ಡ್ ಟು
Therefore, there is no finding regarding the will.
ಇನ್ನು ಕೊಡ್ಲಿಲ್ಲ
Your lordship, one submission, your lordship.
contended that execution of the wills during the penance of
ನಿಮಿಷ, ನೀವು will ಮೇಲೆ claim ಮಾಡಿದ್ರೆ, somebody has to determine, civil court has to declare that you have succeeded to the property on the basis of the will. Merely on the basis of the will, the revenue interest can't be changed, correct?
Moreover, your lordship, partition suit is
Lord.
partly decreed in my favor.
The title has been determined, but the issue was not framed by the honorable
If
court.
the issue is not framed, that
Issue
means,
was not framed.
the question of the will has not been gone into at all.
Yeah, not yet to decide because of these petitioners are failed to establish their title, then the honorable
Now,
court
if there is,
confined to the only to the
No.
extent of issues.
if there is no will,
Yes, ma'am.
you are out of the picture,
Yes, ma'am.
then the property goes back to Venkatrayapa's brother's children.
They're class 2As.
So it will go back to them.
Yes, ma'am.
You will not get the property.
Yes, ma'am.
So until you file a suit, establish your rights under the will. How can the Kata be
The
changed?
very testator himself contended before the trial court in verse 52, my lord.
So the civil
Testator
court,
himself.
so the Tahsildar can give a finding that the will is proved.
No, he is not given, but that finding he is not given.
Then I think you have to go to the civil court and take advantage of the testator's statement and get a declaration. Until then, I don't think the Kata can be
Their
changed in your-
declaration is dismissed, Your Lord.
Because of he is self, that property is a self.
That is your contention.
Entries has been standing.
Tahsildar can't decide this question. As the Venkatrayappa self-acquired property and whether he could have bequeathed the property to you. Even if Venkatrayappa had said in his will, this is my self-acquired property
Yes, ma'am.
and it executed a will in your favor.
Yes, ma'am.
Even then the Tahsildar could not have said, I will change the Kata.
No. OS number 52 of 99, the suit was disposed in the year 2000. Thereafter only the Tahsildar affected the entries.
Agate ಹೇಳಿ ನೀವು. That is the argument, isn't it?
After
Can the
that,
Tahsildar enter your name on the basis of a will?
no, judgment after passing the judgment.
I asked you again repeatedly, in the suit, was an issue framed regarding the validity of the will?
No, then the honorable court not framed that issue.
So then what is the effect?
The issue was not framed by the honorable.
what is the
court in
effect?
that. Of course, I need to seek for framing up that issue or otherwise to amend that, my return.
ಇದೆಲ್ಲ ಆರ್ಯ ಪೆಂಡಿಂಗ್ ಇದೆಯಂತಲ್ಲ ಆರ್ಯ ಬೇಕಾದ್ರೆ ರೈಸ್
RA pending ಇದೆ because that was dismissed.
Two
for-
sale deeds has been
Later it was
executed,
restored.
Your Lordship. Two sale deeds has been executed by R4, Your Lordship,
in favor of,
in favor of some third parties, Your Lordship.
and they are parties in the suit.
They are not parties in the suit, Your Lordship. It is executed on 6/2/2025, Your Lordship,
Petitional
recently.
ಇಲ್ಲ sir. ಬಗ್ಗೆ ನನಗೂ ಗೊತ್ತಿಲ್ಲ ಇದೆ. Petitional
I'll
ಇಲ್ಲ.
set aside this order and give you liberty.
Let me please file an objection statement to the petition along with my documents and judgment. It's one week time.
Shri AG accepts notice for respondents 1 to 3. Name ಹೆಸರು?
Anjane.
Okay. Shri Anjaneya AB accepts notice for both respondent. He seeks for two weeks time, file his objections, released on terms. Till such time, the impugned orders shall remain stayed.
17.
Grateful, Your Lordship.
Number 19. Lakshmi Narayana is.
Yeah, for the petitioner in this case, my lord. But I am seeking to quash the annexure A, my lord. Petitioner being the rightful owners having acquired under the sale deed in annexure, my lord B.
ಅನಧಿಕೃತ ಬಡಾವಣೆಯನ್ನು ತೆರವುಗೊಳಿಸಲು.
Also, that annexure C and D, my lord, may be looked into at page number 30.
1 minute.
It is already converted to residential purpose, my lord, on the basis of, my lord, annexure C. That is the planning authority having given the technical report. Annexure C, my lord, at page number 28. Planning authority has already given the no objection technical report for conversion of the property for residential purpose. Thereafter, it has been converted, my lord.
Where is
And-
the conversion?
Conversion at page number 30, my lord, annexure D.
ಏನ್ ಮೇಡಮ್?
Thereafter, the E-Kata has been,
Not questioning the conversion also. After conversion, they have not obtained the sanction.
Not
from
annexure
the appropriate
H, my lord.
authority.
I have, after the notice have been
Authority.
notices are issued, my lord, that notice have been only shown to the petitioners. Based on that notices, my lord, he has given a representation that 3 months' time may be given for me to provide documents, my lord.
The order of conversion
Please,
mandated that you obtain the approval of the planning authority for the
please, my lord,
purpose.
please, my lord, it
You-
says
you-
so, my lord, yes, my lord, it says so, my lord.
Have you
Even
obtained-
before I make such applications and
obtained it?
process, not yet, my lord. I
So
have
do-
not yet made, my lord. I have sought 3 months' time from the respondent.
Until then, don't form the layout.
No, my lord.
That is
I
all
may
that
be
has been done.
permitted, my lord, I may be permitted, my lord, a 3 months grant may be, but time may be granted, my lord. I may make such applications and necessary fees, and then, my lord, I will submit documents. But I have sought 3 months' time.
Will you undertake not to form the layout?
Please,
You will undertake.
please,
It is the case of the petition.
only on mercy, my lord, I am standing before my lords.
that
Set aside.
the impugned notice has been issued calling upon him not to form the layout since he has not obtained the appropriate approvals from the planning authority. The petitioner admits that the planning authority had granted a no objection to enable him to secure an order of conversion at the hands of the deputy commissioner. And the deputy commissioner had indeed passed an order of conversion on 18/1/2024, permitting the petitioner to use the land as per the reservation made in the master plan. It cannot be in dispute that one of the conditions imposed while granting the order of conversion is that the petitioner is required to obtain the approval of the appropriate planning authority before he takes advantage of the order of conversion. Admittedly, the petitioner has not secured the permission of the planning authority for formation of the layout. In that view of the matter, the passing of the impugned order, which basically restrains the petitioner from forming a layout, cannot be found fault with, though the order also indicates that he would be evicted. Learned counsel for the petitioner submits that the petitioner is in the process of securing the approval of the planning authority for the formation of the layout, and he also undertakes that he will not form the layout until the planning authority grants him the required approvals. And therefore, the order passed by the Tahsildar should not be given effect to. In view of the fact that the petitioner has undertaken not to form the layout without obtaining the approval of the planning authority, in my view, the Tahsildar is required to desist from implementing the order at Ancestral till the petitioner obtains an approval from the planning authority. If without obtaining the approval of the planning authority, the petitioner were to attempt to put up a layout, form a layout, the Tahsildar will be at liberty to take appropriate action pursuant to Annexure A.
Due process of law.
Is fully disposed of.
Due process of law.
ಎಲ್ಲಾನು ಡ್ಯೂ ಪ್ರೊಸೆಸ್ ಆಫ್ ಲಾ ತಾನೆ.
ಸ್ವಾಮಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಇದರಲ್ಲಿ ನೇರವಾಗಿ ಹೇಸ್ಟಿಲಿ ಮ್ಯಾನರ್ ನಲ್ಲಿ ಅವರು
ನೀವು ಎಸ್ಟಿಲಿ ಮಾಡ್ಬಿಡ್ತಿರಲ್ಲ.
ನೋ ಮೈ ಲಾರ್ಡ್, ಐ ಹ್ಯಾವ್ ಆಸ್ಕ್ಡ್ ಶಾರ್ಟ್ ಟೈಮ್ ಲಾರ್ಡ್ annexure
Strictly speaking, they should have cancelled the order of conversion. If he accepts notice for response.
For order seal number 23.
Achha.
Yes, Vishweshwaraya.
It is noticed that the cost of rupees 1,000 imposed on 12/6/2017 has not been deposited, though more than 8 years have elapsed. This indicates that the petitioner is not interested in pursuing the petition. Petition is therefore dismissed.
Number 21.
Who's R6? Who's R6?
R6 is petitioner steps is already taken.
R6 yaru?
R6 is the owner of that property. He is also claiming that I am one of the owner of that property. ಇದು ಅಬೆಟ್ ಆಗಿದ್ದು ಸ್ವಾಮಿ, then I filed the application, then the set aside abatement ಆಗ್ತದೆ.
It is stated the need placement of office to verify. Petitioner is permitted to take out notice in R6 personally. ನೀವೇ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ ಅವರು.
ಎರಡು ಸರಿ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದೆ ಅದರಲ್ಲಿ, ಅವರು ಹೋಗ್ತಿಲ್ಲ ಅದರಲ್ಲಿ. ಅದರ್ವೈಸ್ ಐ ವಿಲ್ ಟೇಕ್ ದಿ
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ
ಐ ವಿಲ್ ಟೇಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡೋಕೆ.
Was there a council appearing for him earlier?
ಇಲ್ಲ, ಅವ್ರು ಯಾರು ಅಪೇರ್ ಆಗ
2011 ಕಂಡ್ರೆ ಎಷ್ಟು ದಿನ ಅಂತ ಇಟ್ಕೊಳ್ತೀವಿ?
2020 ಅಲ್ಲಿ ಮತ್ತೆ ಅಬೆಟ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿದ್ದು.
ಅದೇ does it survive?
ಎಸ್ ದಿಸ್ ಸ್ಟಿಲ್ ಅದ್ರ ವಾಟರ್ ಟ್ಯಾಂಕದಲ್ಲಿ ಪಂಚಾಯತಿ ಅಂತ ಹೇಳ್ಕೊಂತಿದಾರಲ್ಲಿ. ದಟ್ ಇಸ್ ಆ ಸರ್ವೆ ಪ್ರಕಾರ.
What is the prayer in the writ petition?
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಇದ್ರೆ ನೀವು
ಇಲ್ಲ,
ಸಿವಿಲ್ ಕೋರ್ಟ್
ಸಿವಿಲ್ ಕೋಡ್
ಇಲ್ವಾ?
ಇಲ್ಲ. ಈ ಸರ್ವೆ ನಂಬರ್ ಬೇರೆ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಸಿವಿಲ್ ಸೂಟ್ ಇದೆ.
ನೀವು ಸರ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ವೇಸ್ಟ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ.
ಐ ವಿಲ್ ಟೇಕ್ ನೆಸೆಸರಿ ಸ್ಟೆಪ್.
Seal number 22, Shri B.K. Manjunath.
When the contesting respondent, first respondent, Pambalamma Melody, she died on 30/8/2016 without any legal heirs. Now, my lord, I have to file an application under order 22 rule 4A to appoint the Administrator General, my lord, to represent her. I will have filed next week.
What is Annexure B?
Annexure B is the order of the Assistant Commissioner. My lord, setting aside the entries made in favor of the petitioner's brother way back in 1954. My lord,
Are you related to Umbalama?
no, we are not at all related. She is totally a stranger, my lord. She is totally a stranger. And she challenges 54 entries in the year 1995, saying that my husband has
The
purchased.
reason?
A reason, but what the reason the Assistant Commissioner says is, kindly see, my lord, Annexure A. The order passed by the Assistant
Page,
Commissioner.
page 14,
Swami,
page 14.
yes, please. Operative portion, your lordship will get it.
No, page number 14.
15, my lord, may,
14 in the last paragraph.
please. Merit. ಉಭಯತ್ರರ ವಾದ ವಿವಾದಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ವಿವಾದದ ಸರ್ವೆ ನಂಬರ್ 73, 4 ಎಕರೆ 28 ಗುಂಟೆ 33 ಗುಂಟೆ ಜಮೀನನ್ನು ಕಲ್ಲಿನ ದ್ಯಾವೇಗೌಡನ ಮಗ ಹಾಲಿ ಗೂಡಲೂರು ತಾಲೂಕು ದೇವರಸೊಲೆ ತೋಟದಲ್ಲಿರುವ ಕಾಳೇಗೌಡರ ಕರಿಗೌಡರ ಮಗ ಜವರೇಗೌಡನಿಗೆ ದಿನಾಂಕ 19/6/54 ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. That is this, my lord, this Javaregowda is the brother of the petitioner. Among the brothers, there is no dispute, my lord. ಅದೇ ರೀತಿ ದಿನಾಂಕ 22/8/52 ಚಕ್ಕನಹಳ್ಳಿ ಕಲ್ಲಿನ ದ್ಯಾವೇಗೌಡರ ಮಗ ಕಾಳೇಗೌಡರು ಸಣ್ಣ ಸಿದ್ದೇಗೌಡರ ಮಗ ರಾಮೇಗೌಡರಿಗೆ 33 ಗುಂಟೆ ಜಮೀನನ್ನು ಕ್ರಯಕ್ಕೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಈ ಕ್ರಯದ ಪ್ರತಿ ಆಧಾರದ ಮೇಲೆ MR 14/52/14/1955 ಒಂದು ಖಾತೆ ಮಾಡಿರುತ್ತಾರೆ. ಅಲ್ಲಿಂದ ಮುಂದೆ 82-83ರವರೆಗೂ RTC ಕಾಲಂ 9 ಮತ್ತು 12/2ರಲ್ಲಿ ಶ್ರೀ ರಾಮೇಗೌಡರ ಹೆಸರು ಬಂದಿರುತ್ತದೆ. ದಿನಾಂಕ 19/6/54ರಲ್ಲಿ ಕ್ರಯವಾದ ನೋಂದಣಿ ಸಂಖ್ಯೆ ನಂಬರ್ 1124 ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 19/9/80ರಲ್ಲಿ ಖಾತೆ ಮಾಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಇತ್ತೀಚೆಗೆ 3 ಜನ ಸಹೋದರರುಗಳು ಬೋರೇಗೌಡ, ಜವರೇಗೌಡ ಮತ್ತು ಕೆಂಪೇಗೌಡರುಗಳು ಹಾಲಿ ಅನುಭವದಾದಂತೆ ಖಾತೆ ಮಾಡಿಕೊಂಡಿರುವುದರ ಮೇರೆಗೆ MR 95/96 ದಿನಾಂಕ 18/11/96 ರಂದು ಖಾತೆ ಮಾಡಿರುತ್ತಾರೆ. ಸ್ಥಳ ತರಿಕೆ ಸಮಯದಲ್ಲಿ ಗಮನಿಸಿದಂತೆ ಮೇಲ್ಮನವಿದಾರರು ವಿವಾದದ ಜಮೀನನ್ನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿಲ್ಲದಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. She never cultivated the land, my lord. ಇದಲ್ಲದೆ ಎದುರುದಾರರು
Registered sale in her favor.
Please, my lord. No, that's that.
What is your claim? Your claim is on the basis of possession.
No, my lord. My claim is on the basis of the registered sale deed, my lord,
She has a
executed
registered sale deed earlier in.
in favor of the petitioners.
No, she had a registered, her husband's name was there in the Kateda.
He is subsequent to purchaser. No, he was not the khatedar, my lord. I have produced Annexure A. Kindly see, my lord. The mutation.
When did your name come in?
My lord, 1954 itself, my lord. Annexure A in page 10.
What?
In page, my lord, 11 typed copy I have produced, my lord. This is the mutation, my lord, which was made. Idu 11 gunte among the 3 brothers, my lord, of the petitioner.
95/96.
95/96.
When this was the first time your name came in?
No, my lord. My brother name was entered in, my lord.
Where?
Earlier to that.
Where?
Earlier to that in 1954.
Elliday.
But there is a reference to this, my lord.
Her name was there from 54 to 87. Without challenging that, her name is removed. Her name was there on the basis of a sale deed. Before her name was deleted, was any proceedings held?
No, my lord. She is the purchaser from a person who had no title.
ನೀವು civil court ಹೋಗಿ
ಅಲ್ಲ ಇವಾಗ ನಾವು ಎಂಟ್ರೀಸ್ ಇದೆ, ನಮಗೆ ಬೇರೆ ಯಾರಾದ್ರೂ ತೊಂದರೆ ಮಾಡ್ಬೋದು. Now there is nobody to contest, even go to civil court. I will have to file a suit against a dead person. ಮೇಲೆ
ಸುಮ್ಮನೆ ಅಬೇಟ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ತೀನಿ, ನೋಡ್ಕೊಳ್ಳಿ, ಹಂಗೇನ ಮಾಡ್ಕೊಳ್ಳಿ.
may make one request. I will implead my lad administrator.
What will you do? Ultimately,
Ultimately, this order has to be
ultimately,
passed.
I have to uphold this order because her name was there. Without holding an inquiry, it has been removed. Therefore, I can't find fault with this order. I can only ask you to go to the civil court and establish all this.
But she is the subsequent purchaser, her
That's the
husband.
matter. That's a matter that you have to establish in the civil court. The Tahsildar or the AC could not have done that. Admittedly, her name, her husband's name was there in the records.
Earlier to that, my lad.
Abated ಅಂದ್ಬಿಡ್ತೀನಿ, ನೀವು ಆಮೇಲೆ ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ. Then steps have not been taken. Despite the fact that the first respondent passed away way back in the year 2022. And though an order was passed regarding taking of steps on 17 to 2022, the writ petition has stood abated.
Seal number 23, Srimati Parinita.
Who's R5?
Twenty-three.
Though it was reported on 2/1/2023 that the fifth respondent was dead, no steps have been taken. Since steps have not been taken within the prescribed period, the writ petition as against fifth respondent shall stand abated. However, since what is annexure K, madam?
Is the notice. Section K is the notice issued by the.
No, who is the fifth respondent then?
With Veeranna.
ಯಾರು ಮೇಡಮ್ ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂದ್ರೆ?
Landlord, he is the landlord of the petitioner.
Is it survey for consideration now?
This Veeranna is the landlord of the petitioner.
Interim order ಇತ್ತ?
This is issued, my lord, because bar and restaurant ಮಾಡ್ತಾ
There is no
ಇದ್ರು.
appearance on behalf of the petitioner. Since the order dated 2/1/23 is not complied with, the writ petition is dismissed from use prosecution. I don't think it survives for consideration.
Seal number 24, Shri V. Vishwanath.
Petitioner, my lord,
Who's
to
R4?
may be granted, my lord, take step, my lord.
ಯಾವಾಗ?
R4.
When did he die?
ಅಲ್ಲ, ಒಂದು 2 ವಾರ ಆಯ್ತು. ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ ನೋಟಿಸ್.
ಯಾವಾಗ? 21 ಇಂದ ಮಾಡಿಲ್ಲ. Since ಹಾಕಿದಿರಾ?
ಹಾಕಿ
ಏನಕ್ಕೆ ಹಾಕ್ಲಿಲ್ಲ?
Publish ಮಾಡಿಲ್ಲ.
DNP ಮಾಡ್ಲಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ,
21-22 ಇಂದ ಏನು ಮಾಡಿಲ್ಲ.
ತಗೊಳ್ಸಿ ಸ್ವಲ್ಪ ಪೇಪರ್.
A week's time is granted to take steps to effect service of notice on the LRs of deceased R4. If steps are not taken within a week's time, the writ petition itself will stand dismissed on prosecution without further reference to.
Seal number 25, Shri T. Prakasha.
I have taken the substitute surveys for so far as R1, R5A to 5C,
The paper
R10,
publication
11,
carried out in respect of R5A and R5C,
R10.
R10 to 12, 13A, clear and frustrated is accepted. They are called out and remain absent. Hence, notice to them is sufficient. What is this? IA 1 and 3?
Yes, my lord. IA1, to bring the LRs of the, to bring the LRs of deceased on record.
This is R5B now.
Separate IA ತೆಗೆಯೋ.
R5B. Notice of good.
Lord, so bring the LRs of R5B, my lord.
IA 1/25.
I filed separate
IA
application.
3/25. Petition is permitted to take out notice on the proposed LRs personally in addition. The memo for treating R15 as the LR of R14 is accepted. Then not pressing of IA 2 to 3.
Yes, my lord, because earlier I have filed a combined application, therefore office has raised an objection. Therefore, I filed a separate application.
4 of 2022 is dismissed as not pressed.
Yes.
First for IA 1 for vacating.
No, I'm for respondent number 4, ma'am. We have not done.
ಏನ್ ಸ್ಟೇ ತಗೊಂಡಿದ್ದೀರಾ?
Sorry?
ಏನ್ ಸ್ಟೇ ತಗೊಂಡಿದ್ದೀರಾ?
Stay is only with regard to the land tribunal has granted the occupancy rights pertaining to corporation property. We are the owners of the property, my lord. And the land.
ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ರೆ ತಗೋಬಹುದು, ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ.
ಅಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗೋಗುತ್ತೆ ಸರ್. ಇದೊಂದು ಮಾತ್ರ ಬಾಕಿ ಇದೆ.
Post after service of notice on the proposed LRs of R5.
Seal number 26, in Murali BS.
For the petitioners. But as per the final orders, my lord, I had purchased, my lord, demand draft and submitted, my lord, to the authorities. Or they have refused, my lord, to accept the demand draft. Twice, my lord, I attempted to.
Yes.
But the original, my lord, is here with me.
Not ಅದರಲ್ಲಿ ಅಥಾರಿಟಿಲಿ ಅಕೌಂಟೆಂಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಫೀಲಿಂಗ್ ವೆಲ್ ಅಂತ ಹೇಳಿ ಅಕೌಂಟೆಂಟ್ ಇರ್ಲಿಲ್ಲ ಅಂತ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಸರಿಯಾಗಿ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ತಗೊಂಡಿಲ್ಲ ಮಲಾಡ್ಸ್. ದಟ್ ಇಸ್ ದ ರೀಸನ್.
ಅಲ್ಲ ಡಿಡಿ ತಗೊಂಡು ಹೇಳ್ಬೇಕು ತಾನೆ, ಇನ್ನೂ ಕಮ್ಮಿ ಇದೆ ಜಾಸ್ತಿ ಇದೆ ಅಂತ.
ಹೇಳಲಿಕ್ಕೆ ಅಕೌಂಟೆಂಟ್ ಇಲ್ಲ, ಹಾಗಾಗಿ ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ. 2 days ಟೈಮ್ ಮಲಾಡ್ಸ್. 2 days ಟೈಮ್ ಕೊಟ್ರೆ.
But we met the commissioner himself, my lord. He says, my lord, he wants to secure instructions from the advocate. And 4 hours, my lord, we sat before him. He was not.
Why do you want me to issue condemned notice against him?
Let him accept, my lord, the demand draft. If there is anything, my lord, let him.
It appears that they want to harass you some more. So let us give them 2 days time.
Please.
You will secure instructions
ಪ್ಲೀಸ್ ಮಲಾಡ್.
and you will receive the demand draft right now.
Please.
That is on the next date. If you don't, the commission will be present.
ಪ್ಲೀಸ್.
Commission ಇದ್ರಲ್ವ ಅವತ್ತು ಆರ್ಡರ್ ಮಾಡಿದಾಗ ನಾನು
ಇರಲಿಲ್ಲ ಇದರಲ್ಲಿ.
ರಿಲೀಸ್ ಡೇ after.
ಮಚ್ಚ.
Seal number 27. Government advocate.
27, Lord, I appear for the respondents.
What is the subject?
They have to find, they have to, Lord, amend the cause title. And in respect of one of the respondents, Lord, notice was issued to bring on record the legal representatives. They have filed memos to accept notice on behalf of.
What is the order that is challenged?
Matter, Lord, of course, it's a petition
Both of
by.
you have challenged it.
Yeah, no, we have sought for Mandamus for implementation of the order. This is a case where, my lord, about 240 feet into 60 feet of land was encroached by the regional transport officer, totally 4 acres, 13 guntas. Then we filed an application under section 67, subsection 2 of the act for deciding the claim. Deputy Commissioner initially rejected it. The Karnataka Appellate Tribunal held that indeed there was an encroachment and the government was there without any authority. Review petition was filed, that is rejected. It is against that order the state is filed writ petition.
Suit ಹಾಕೋಬೋದಲ್ವ ನೀವು 67 order ಮೇಲೆ?
Correct. In fact, I just before my learned friend says, the state government directed an inquiry to be conducted and a survey to be conducted. Survey was conducted by the Deputy Director of Land Records and found that the 240 into 60 feet was encroached by them. and they were staying there without authority. They are using this property for parking the RTO vehicles and built something there.
Where is this property?
Tumkur.
RTO. It's a prime area, government college pakka.
The suit hakkoli, 672 order itself is against you.
I'm convinced, my lord, the stage is now I have to pay the process.
No, no, we are accepting notice, one of the respondents.
For other, my lord.
In fact, number of times the matter has come up before your lordship. The state has failed to take notice. Then we have to file an impleading application saying that as LRs we may be permitted to come on record. But the service is complete.
Who's the LR of, who wants to come on record?
No, one of the, who is passed away?
You accept notice for the LRs of R1?
Yes, yes. R1.
Who's the counsel on record?
Sir, Lord, this is which respondent? Respondent number 2 and 3, my lord.
No. The application is filed for,
Bringing
they've
the
also
LR.
filed an application to bring the LRs on record. You also have filed an application.
We have not already, that application for impleading is allowed.
No, first amendment ಮಾಡಿದಾರಾ?
Madila, state has to.
We will do it. Each time.
No, literally only one aspect. Respondent number 2 is one Jayant Bharamagowda Patil. To bring his LRs on record, Kiran Jayant Patil and Sarojini Jayant Patil are there.
Where is your impleading application? A number? Yes, sir.
Kiran Jayant.
Kiran Jayant Patil is already on record, my lord. Only Sarojini Jayant, I have to take notice for her.
No, we are accept.
Then we will amend the petition and we will argue the matter.
No. There's one application filed to bring the LRs of R1 on record.
R1 ನಲ್ಲಿ ಒಬ್ರು already on
If they are already on record, by way of-
ತಾಯಿ ಇರ್ಲಿಲ್ಲ. ಅವ್ರು ಇವಾಗ ಬರ್ತೀವಿ ಅಂತ ಅವ್ರು ಬಂದಿದ್ದಾರೆ. We will amend the petition.
let us see whose application have you filed for impleading?
Lord, we have filed impleading application to bring the LRs of Sanjay Jayant Patil, R3's Jayant Patil. Idu ಎರಡು application ಹಾಕಿದ್ವಿ. Sanjay Jayant Patil, respondent number 3. Leading application. Idu ಹಾಕಿಲ್ಲ impleading. Look, we have filed impleading application to bring on record the legal representatives of Sanjay Jayant Patil, who is respondent number 3. There is no controversy about that. Now, the only person who has to come on record is
LR
the
of R1.
R1 ಗೆ.
What is for it?
R2 ಗೆ, not R1 ಗೆ, R2 ಗೆ.
One alva.
ಇಲ್ಲ R1 ಗೆ ಇದ್ದಾರೆ. R1 ಗೆ ಜಯಂತ್ ಬರಮಗೌಡ ಪಾಟೀಲ್. Yes, correct. I'm sorry. That is R1. We'll take notice. R1, correct.
Sanjeevani, right? Sanjeevani B. Nawadgi accepts notice for the proposed respondents in IA 1/2024. Since right to sue surveys, the applications filed in IA 1/24, and the applications to set aside the delay, set aside the abatement and the delay are allowed. Was told to be amended. Then what is this non-filing of wakalat behalf of R3 and R4?
File ಮಾಡ್ತಾರೆ. We'll file.
Srimati Sanjeevani also undertakes to file wakalat on behalf of R3 and R4.
File ಮಾಡಿ.
Government advocate is directed to amend the cost title immediately. ಈಗಲೇ ಮಾಡಿ
ಆಯ್ತು.
the list.
Any date next week if it's convenient.
The list.
Number 28, Srimati Parvati Nair.
And for the second respondent. Complied to the order passed by this honorable court dated 28/1/2010 by depositing a sum of rupees 25,000 before the Kidwai and directed this third respondent to execute the kata in the name of the petitioner.
ಮಾಡಿದ್ರೆ ಖಾತಾ ಮಾಡಿದ್ರೆ ಅವ್ರ ಪರ
ಖಾತೆಗೆ ಸರ್ವೆ ಮಾಡಬೇಕು ಅಂತ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ. ಹಾಗಾಗಿ ದೇ ಆರ್ ಮೇಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಬಿಫೋರ್ ದಿ ಸರ್ವೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಂಡ್ ಟು ಗೆಟ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಸರ್ವೆ. Then ಖಾತೆ will be executed.
The direction was to conduct, to register the kata, not to conduct a survey. You will again sit in judgment.
PDO ಏನೋ ಸರ್ವೆ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂದ್ರೆ ಒಂದು ರೆಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ.
ಹಂಗಾರೆ ಏನು ನನ್ನ ಆರ್ಡರ್ ಇಗ್ನೋರ್ ಮಾಡಿ ತಿರ್ಗಾ ಸರ್ವೆ ಮಾಡಿ ಆಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ ಖಾತಾ ಮಾಡೋಕೋಬೇಡ ಅಂತ.
ಅದು ನಾನು ಐ ಆಮ್ ನಾಟ್ ಎಫೇರಿಂಗ್ ಫಾರ್ ದೆಮ್, ಈವನ್ ದೆನ್ ದಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಟು ದಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಸ್ ದೇ ವಿಲ್ ಡೂ ಇಟ್.
What place was second respondent?
ಐ ಆಮ್ ಫಾರ್ ದಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಗ್ರಾಮ ಪಂಚಾಯತಿ
ಅಲ್ಲ, ದಿ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್.
ಇಲ್ಲ, ಗ್ರಾಮ ಪಂಚಾಯತಿ ಯಾರು?
Gram
Panchayat is respondent number 3, my lord.
That is not registered in the.
No, my lord, as of now, it's still not registered. And what seems to be happening, my lord, is they're making all sorts of issues to register, like my learned friend has said regarding survey and all. And my lord's order was also to register the Karta within 2 weeks, my lord. It's been over a month now since the date of the order, my lord.
The third respondent to state as to why the order dated 28th of January 2025, which directed it to reach the Karnataka for the petitioner, remains uncomplied. The list on so and so. If the Kata is not registered by then, the third respondent shall be personally present before the court. Inform Prasanna Kumar.
Yes, my lord.
Yes, ma'am.
Number 29, Sri Praveen HP.
Appearing for the petitioners, my lords, filing memo for withdrawal in this specific.
Requested petition is dismissed as well.
Seal number 30, Sri Vivekananda N.
My lord, I seek 1 week time. I seek 1 week time to comply with the officer.
Weeks time.
Please, ma'am.
Seal number 31.
Yes.
ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಕಮಿಟಿ ಮುಂದೆ ಹೋಗಿತ್ತು. ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಕಮಿಟಿ ಮುಂದೆ ಹೋಗಿತ್ತು. ಅವರು ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿಲ್ಲ, ಲಾಯರ್ನ ಇಡ್ಲೇಬೇಕು ಅಂತ ಇದು ಮಾಡಿದ್ದಾರೆ.
ಲಾರಿ ನಡೀತೀರಾ? ಲಾರಿ ನಡೀತೀರಾ?
ಬೇಕಂದ್ರೆ ಇಡ್ತೀನಿ ಸ್ವಾಮಿ, ಇಲ್ಲ ನಡೆಸ್ತೀನಿ ಸ್ವಾಮಿ.
ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ ಇಟ್ಬಿಡಿ, ಲಾರಿನ ಹಾಕ್ಬೇಕು. The party in person who is present requests for a week's time to secure, to engage a counsel. Relist on by which time you shall engage a counsel.
10th March. Seal number 32, Sri Ranjan Kumar.
Appear for petition, my lord. Will comply it, my lord, during the course of the day. When, my lord, this matter.
What is annexure M and K?
Annexure M, my lord, is the order of the deputy commissioner. My lord, confirming the order passed by the assistant commissioner, annexure K. My lord, the petitioners are in unauthorized occupation of land, that is scheduled land, for several years, my lord. Thereafter, they filed form number 50. Then subsequently, my lord, grant was made in their favor. After lapse of, my lord, nearly 3 years, my lord, 3 or 4 years, my lord, the assistant commissioner sumo to initiate proceedings and, my lord, cancel the grant. And against that, my lord, I preferred an appeal to the assistant commissioner, and that also came to be dismissed, my lord. The reason for dismissal is that, my lord, the form number 50 has not been accepted, and there is no entry in respect of, my lord, the entry of form number 50, acceptance of form number 50, my lord, in the register maintained by them. And also, my lord, that I have, my lord, more sufficient land, more than that, my lord, that it says that my brother and mother has lands, my lord, that doesn't belong to the family. And therefore, my lord, against that, my lord, I preferred, I challenged that order before the DC. Now, DC also, my lord, says, confirming the order of AC, my lord, says that I have excess of land. Against that, my lord, I preferred an appeal to Karnataka Appellate Tribunal, which is at Annexure A.
And I refer to, my lord, relied upon 6 judgments wherein, my lord, to say that the initiation of proceedings should be made, my lord, within a period of, within reasonable time. That is, my lord, as per the Honorable High Court's order.
Even if it's by way of fraud,
It is not fraud, my lord. It's a genuine case, my lord, wherein they have not filed.
they were to say that there's no form number 50 at all.
No, they say, my lord, there is no entry. But, my lord, form number 50 itself is produced. I have
Where is the
produced.
finding of the appellate tribunal on this?
Appellate tribunal, my lord, there is no finding. Kindly see, my lord, page number 18, my lord, is the order. The reasons, my lord, at page number 22. First para, my lord, is the explanation, my lord, how the property has devolved. The order dated 15/9/2000, second para. Absolutely no reasons, my lord.
In Madam TT fine ತಗೊಂಡಿದ್ರೆ, how can you say that no form number 50? And para 7, page 22.
No, my lord.
There is an application form number 50 dated so and so in the file of respondent number 2.
We are not telling that the form 50 is not forthcoming, but under form 50, coffee plantation cannot be granted. That is the content.
ಬಾರಿ ಇದೆಯಾ?
That is observation by the
Plantation ಗೆ
DC.
there is
my
a
lord.
bar, but ಇದು unauthorized ಆಗಿತ್ತು. We cultivated and, my lord, we have grown coffee in that.
No, if there is a bar for granting that land,
ಅಲ್ಲ, ಪ್ಲಾಂಟೇಶನ್ ಇವಾಗ ಆಗಿರೋದು. ಈಗಲೂ ಅದಕ್ಕೆ ಅರ್ಲಿಯರ್ ಇಟ್ ವಾಸ್ ಅನ್ ಅನ್ಆಥರೈಸ್ಡ್, ಖಾಲಿ ಜಾಗ ಇತ್ತು. ಅಂಡ್ ವಿ ಎನ್ಕ್ರೋಚ್ ಇಟ್ ಅಪಾನ್. ಅಂಡ್ ನಾವು ಕಷ್ಟಪಟ್ಟು ಬೆಳೆದಿರೋದನ್ನ ಇವರಿಗೆ ಪ್ಲಾಂಟೇಶನ್ ಅಂತ ಹೇಳಿದ್ರೆ, ದಟ್ ಈಸ್ ದಿ ಗ್ರೌಂಡ್ ವಿಚ್ ಐ ಟೇಕನ್ ಬಿಫೋರ್ ದಿ KAT.
Only on that.
which is that provision which bars
94 subsection 4 of 94A.
94A.
ಇಲ್ಲಿದೆ ಮೇಡಮ್ ಪ್ಲಾಂಟೇಶನ್ ಲ್ಯಾಂಡ್ ಕೊಡಬಾರದು ಅಂತ. Section 4. What is the extra family holding ಎಷ್ಟಿದೆ ಅಂತ ಹಾಕಿದ್ದಾರೆ?
On 2-3 counts, the grant has been cancelled, my lord. Nearly they own exceeding the ceiling limit as provided under 94A, my lord.
Can you
94A
include
clearly,
suppose the family is divided, then can you include the family?
as on the date of the application, if he holds more than ceiling limit, they are not entitled.
Where is the finding that he was holding it?
That is
at
the
page
finding. DC has given the detailed finding. It is at page 58.
Page?
58.
Is the appeal memo.
Nandralli, DC order, my lord.
Page number 45, AC order, my lord, it refers. That has been confirmed by the DC.
Where is the order of the DC?
DC's order is, my lord, at page number 50. It starts from page number 52.
58 ಅಲ್ಲಿ they made
And
some
reasoning, my lord, para 7 of the DC's order. ಪ್ರಕರಣದಲ್ಲಿ 1-2ನೇ ಪ್ರತಿವಾದಿಗಳು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುವ ಮೂಲ ಕಡತಗಳನ್ನು ಪರಿಶೀಲಿಸುವ ಮಂಜೂರಾತಿ ಕಡತದಲ್ಲಿ ನಮೂನೆ 50ರ ಅರ್ಜಿ ಲಗತ್ತಿದ್ದು ಮೇಲ್ವಿಚಾರರು ಕೊಂಗಣ ಗ್ರಾಮದ ಸ್ವಸಹಾಯ ಮಂಜೂರಾತಿ ಕೋರಿ
Read from page 67, para 9.
ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ನಿಯಮಗಳನ್ನು ಜಮೀನು ಮಂಜೂರಾತಿ ಮಾಡುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಜಿಲ್ಲೆಯ 3 ತಾಲೂಕುಗಳಲ್ಲಿ ಕಳೆದ 5 ವರ್ಷಗಳಲ್ಲಿ ಅಕ್ರಮ ಸಕ್ರಮ ಮಂಜೂರಾದ ಪ್ರಕರಣವನ್ನು ಪರಿಶೀಲಿಸಿ ಅರ್ಹ ಫಲಾನುಭವಿಗಳಿಗೆ ಮಾತ್ರ ಸಕ್ರಮಗೊಳಿಸಲು ಅನ್ವಯವಾಗುವಂತೆ ಸಮಗ್ರ ತನಿಖೆ ನಡೆಸಲು ಲೋಕಾಯುಕ್ತ ವರದಿ ಮೇರೆಗೆ ಗೌರವಾನ್ವಿತ ಲೋಕಾಯುಕ್ತ ವಹಿಸಿದೆ. ಅದರಂತೆ ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತ ದಿನಾಂಕ 3/8/2018 ಸರ್ಕಾರಕ್ಕೆ ವರದಿ ಸಲ್ಲಿಸಿದ್ದು, ವರದಿಯಲ್ಲಿ ಅಕ್ರಮ ಸಕ್ರಮ ಸಮಿತಿಯ ನಿಯಮಬದ್ಧವಾಗಿ ಮಂಜೂರಾತಿ ಮಾಡುವ 338 ಪ್ರಕರಣಗಳನ್ನು ಜಮೀನನ್ನು ಸರ್ಕಾರದ ವಶಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲು ಸಂಬಂಧಪಟ್ಟವರಿಗೆ ನಿರ್ದೇಶನ ನೀಡುವಂತೆ ಹಾಗೂ ನಿಯಮಬಾಹಿರ ಮಂಜೂರಾತಿಯಲ್ಲಿ ಶಾಮೀಲಾಗುವ ವ್ಯವಹಾರ ಮಾಡಿರುವ ಅಧಿಕಾರಿ ನೌಕರರ ವಿರುದ್ಧ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸುವಂತೆ ಸರ್ಕಾರಕ್ಕೆ ಶಿಫಾರಸು ಮಾಡುವುದು ಗಮನಿಸಿ ಬರುತ್ತದೆ. ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ನಿಯಮಾವಳಿ 66 ನಿಯಮಗಳಿಗೆ ವಿರುದ್ಧವಾಗಿ ಮಾಡುವ ಮಂಜೂರಾತಿ ಬಗ್ಗೆ ನಡೆಸಿ 108ಕ್ಕೆ ರೆಡಿ ಮಂಜೂರಾತಿಯನ್ನು ವಜಾಗೊಳಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ವಶಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಅಧಿಕಾರ ಹೊಂದಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ದಿನಾಂಕ ಸ್ಪಷ್ಟಪಡಿಸಲಾಗಿದೆ. ಅದರಂತೆ 1ನೇ ಪ್ರತಿವಾದಿಗಳು ವಿಚಾರಣೆ ನಡೆಸಿ ಮೇಲ್ವಿಚಾರಣೆಗೆ ವಾದ ಮಂಡನೆಗೆ ಅವಕಾಶ ನೀಡಿ ಮಂಜೂರಾತಿಯನ್ನು ವಜಾಗೊಳಿಸಿ ಆದೇಶಿಸುವುದು ಕಂಡುಬರುತ್ತದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಮೇಲ್ವಿಚಾರಣೆಗೆ ವಾದ ಮಂಡಿಸಲು ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ನೀಡಲಾಗುತ್ತದೆ. ಮೇಲ್ವಿಚಾರಣೆಗೆ 1ನೇ ಪ್ರತಿವಾದಿಗಳ ಆದೇಶವನ್ನು ಅಲ್ಲಗಳೆಯುವಂತೆ ಹಾಗೂ ವಿರಾಜಪೇಟೆ ತಾಲೂಕು ಅಕ್ರಮ ಮಂಜೂರಾತಿಯನ್ನು ಸಮರ್ಪಿಸಿಕೊಂಡ ಯಾವುದೇ ಪೂರಕವಾದ ದಾಖಲೆಗಳನ್ನು ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ವಿರಾಜಪೇಟೆ ತಾಲೂಕು ಪನ್ನಂಪೇಟೆ ಹೋಬಳಿ ಕೊಂಗಣ ಗ್ರಾಮದ ಪೈಸರಿ ಗ್ರಾಮ 141/1 ಅದರಲ್ಲಿ 495 ಎಕರೆ ಜಮೀನನ್ನು ವಿರಾಜಪೇಟೆ ಅಕ್ರಮ ಸಕ್ರಮ ಸಮಿತಿಯ ಕಾಫಿ ಸಾಗುವಳಿಗೆ ಮಂಜೂರು ಮಾಡಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಮೇಲ್ವಿಚಾರಕರು ಕುಟುಂಬದ ಆಸ್ತಿಯಲ್ಲಿ 50 ಎಕರೆ ಹಿಡುವಳಿ ಜಮೀನು ಹೊಂದಿರುವುದಾಗಿ ಒಪ್ಪಿಕೊಂಡಿರುವುದರಿಂದ 2 ಹೆಕ್ಟೇರ್ಗಿಂತ ಹೆಚ್ಚು ಜಮೀನು ಹೊಂದಿರುವುದು ಸಾಬೀತಾಗಿರುತ್ತದೆ. ಭೂ ಕರ್ನಾಟಕ ಕಾಯ್ದೆ 64 ಕಲಂ 94A ಅಡಿಯಲ್ಲಿ ಪ್ಲಾಂಟೇಶನ್ ಜಮೀನು ಮತ್ತು ಕಲಂ 79(2) ಉಲ್ಲೇಖಿಸಿದ ಜಮೀನು ಸಕ್ರಮಗೊಳಿಸಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. ಹಾಗೂ ಅರ್ಜಿದಾರರು 2 ಹೆಕ್ಟೇರ್ಗಿಂತ ಹೆಚ್ಚು ಜಮೀನು ಹೊಂದಿದ್ದಲ್ಲಿ ಮಂಜೂರಾತಿಗೆ ಅರ್ಹರಾಗಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ದಾಖಲೆಯನ್ನು ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ವಿರಾಜಪೇಟೆ ತಾಲೂಕು ಅಕ್ರಮ ಸಕ್ರಮ ಸಮಿತಿ 950ರಲ್ಲಿ ಕಾಫಿ ಸಾಗುವಳಿ ಜಮೀನು ಮಂಜೂರಾತಿ ಮಾಡುವುದು ಹಾಗೂ ಮೇಲ್ವಿಚಾರಕರಿಗೆ 2 ಹೆಕ್ಟೇರ್ಗಿಂತ ಹೆಚ್ಚು ಜಮೀನು ಹೊಂದಿರುವ ದಾಖಲೆಯಿಂದ ಸ್ಪಷ್ಟಪಟ್ಟಿರುತ್ತದೆ.
Total extent is
4.95
plus 50 cents.
Plus 50 cents, my lord, he says belongs to the family. My lord, family cannot be included under land grant rules.
ಹಿಡುವಳಿ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಬರೆದಿದ್ದಾರೆ.
ಅಲ್ಲ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ,
ಅಲ್ಲದೆ
ಕುಟುಂಬದವ್ರಿಗೆ ಇದೆ ಅನ್ನೋದು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಅದು ಕುಟುಂಬ ಫ್ಯಾಮಿಲಿ does not include, my lord, this.
Madam, secure instructions.
Yes.
AG accepts notice for the respondents to try to secure instructions and if necessary file objections. Interim stay till then. Office objection should also be complied with.
Oblige. My lord, I'll comply the office objections right now, my lord. During the course of the day, I'll comply.
ಇಲ್ಲ annex certified copy ಕೊಡ್ಬೇಕಂತ.
ಆಯ್ತು, week's time, my lord.
Date is-
Oblige.
Seal number 33, Sri Prasanna BR.
Lord, needful is done on 5/11 itself. Needful is already done on 5/11 itself.
Stated that needfulness being
The
done.
suit for Mandamus felon. Similar set of facts already, the order has been passed. Sir,
But madam, what have you said? What is your submission? I was not able to understand.
suit for, this is for Mandamus felon.
Mandamus for what?
We are already passed a order on similar set of facts. Only the survey number has changed.
Hmm.
Thereafter, they have given a representation to dispose these deposits.
Same order.
Next year, earlier there was an order with a direction to conclude the proceedings. Remaining this matter.
Petition is filed seeking for Mandamus. There is second respondent to dispose of matter in merits as read by this court in WP 20752/2023 on 1/4/2024, a copy which is produced on XRF. Not council also places reliance on another order passed in WP 27610/2024, in which this court had directed the CLAO to dispose of case number LND HRP bracket T 78/1112 in terms of the directions issued in WP 21332 bar 23. In the light of the above, this writ petition also disposed of, directing the second respondent to consider the case of the petitioner as already held by this coordinate bench in the aforementioned two writ petitions.
Number 34, Srimati Monisha NS.
I prefer short accommodation in this matter. I prefer short accommodation also. I'll comply with office objections. I need to produce the type copies. Though I have written submission, but they are necessary.
Weeks in.
Please.
For hearing on IA. Number 35, Shri Vivekanand and
Lord, for the petitioner, my lord, just 3 words have to be deleted in that final order, my lord. Paragraph 3 of the order. Paragraph 3, second line, my lord. It is also stated that the wife of the petitioner, that is the mother of the deceased, that portion has to be deleted, my lord. Wife is not the mother. Just that portion has to be deleted. It should only read as it is also stated that the wife of the petitioner also passed away in the very same.
No, that your wife is the mother of the deceased.
No, my lord. Mother of the deceased is separate, my lord. Wife passed away. Father of the deceased has filed a petition.
Stated that the portion of paragraph 3, which states wife of the petitioner, that is the mother of the deceased, should be modified and we indicate as only the wife of the petitioner. It is submitted that the phrase mother of the deceased would be incorrect, since the mother of the deceased was some other person. The right of the above, the following portion, that is the mother of the deceased, shall be struck off from the order.
Much obliged.
Third application. You not paid the court fee?
My lord, once this orders, the correction is done, I'll pay the court fee immediately, my lord.
The petitioner undertakes to pay the maximum court fee, rupees 38,970. As per Schedule 1, Article 6 of the KCF and SV Act. This said statement is taken.
Much obliged.
36, Shri Sampangi Ramaya.
Sole respondent 4 died, my lord. Petitioner is also died on 23. I have filed IA to bring it.
Told the notice, sir.
I do not have any information. No.
Issue notice on IA.
ಅಲ್ಲ ನೋಟಿಸ್ ಆಗಿದೆ, ನೋಟಿಸ್ ಆಗಿ ರಿಪ್ರೆಸೆಂಟೆಡ್.
ಅಲ್ಲ ನೋಟಿಸ್ ಬಂದಿದೆ ವಾಪಸ್ಸು.
ಹಾ,
ಯಾವಾಗ ನೋಟಿಸ್ ಆಗಿದೆ?
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆನ್ 7/3 or 4. Yes, LR.
ಅದೇ ಬೇರೆ IAS.
ಅಲ್ಲ ಅದು ಆಕ್ಚುಲಿ R4 R3 ಅಂತ R4 R1 R2 R3 ತಹಶೀಲ್ದಾರ್ AC and DC.
ಇಲ್ಲ IA 1, 2, 3 is to bring the LRs of the petitioner on record.
ಅದಾಗಿದೆ.
ಅದಾಗಿದೆ. ಇದು R4 ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
R4 for filed IA.
ಅದ್ರ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ತಾನೆ?
ಮಾಡ್ಬೇಕು ಅದು.
Issue notice on IA 6 and 7.
R4 please.
3, 6 and 7.
Notice
ನೋಡಲ್ವಾ?
Some information. Number 37, Shri Prakasha K.
R4 में.
Application file for dispensation of production of certificate copy of audit and 1993. Passed in RRT 14/92/93 is allowed. Then matter?
They have sought for issuance of certified copies pertaining to some entries, my lord. And the authorities have issued endorsement saying that the records are not available.
Next year, G and H.
Yes, my lord. They have issued endorsement saying that those records are not available.
ಎಲ್ಲಿದೆ ಅದು?
Annexure page 27, my lord. Typed copy is 27 and 25 annexure G. Both Tahsildar and AC office have issued endorsement saying that cataloging ಮತ್ತು indexing ಅಲ್ಲಿ
What is the other prayer that is seeking for?
other prayer is setting aside the MR entries ಅಂತಾರೆ. MR entries they have to challenge before the AC. So surely setting aside the order dated 1993 passed by the respondent number 2. Because the mutation entry says that, my lord, presently the land stands in the name of one Boregowda. Through an MR.
ಬರ್ತಾರ ಅವರು?
Silma 38, Shri Kashyap Naik.
The petition challenging land tribunal's order. Respondent number 2 has filed an application for early hearing. I have no objection to the application. Date may be fixed for hearing, lords.
Respondent number 8 to 13, my lord.
Third round of litigation, it will take some time to consider, lords.
Here for respondent number 2, my lord.
Date ಕೊಡಿ. Rule issue ಆಗಿದೆಯಾ?
What?
Rule issue ಆಗಿದೆಯಾ?
Rule issue, ಇಲ್ಲ, but pleadings are complete.
Postal B group.
Third April. Silma 39, Shri Vigneshwar Ayu.
For weeks time to take steps to R10, my lord.
Who's R10? Who's R10?
Proxy counsel.
R10. Annexure R10.
He was not a party in the. Respond number? Here, Rajana.
No, Annexure A ದಲ್ಲಿ he doesn't seem to.
PM Devanna. Annexure A ಹೇಳ್ತಾನೆ.
No, before in Annexure A, he is not a party. Annexure A is the order which is impugned.
Why was he not made a party with the deputy commissioner?
Oh, petition.
He needs to be made a party, Alba.
I'll take steps. Take steps.
Weeks time is granted to do the needful.
Please. Interim order to continue.
You have filed an application for vacating the order, interim order, but
Hearing
the
both-
lordships may fix a date.
Post of disposal of R10, and post of issuance of service of notice on R10.
Please.
For further consideration, seal number 40, Srimati.
I appear for the petitioner in 40.4 minutes is a drain matter. Minutes, I have filed one application for amendment. That's now minutes additional prayer minute to direct the BBMP to minutes acquire the land under the new act. Because during pendency of this petition minutes, they came and demolished the entire house.
In Jagdishwar,
Objections ಹಾಕ್ಬೇಕಾಗತ್ತೆ amendment ಗೆ. Because your lordship aware that by virtue of the apex.
I'll allow the amendment application, file additional objections to the amendment. ಎರಡು ಒಂದೇ ಆಗುತ್ತೆ.
ಇಲ್ಲಿ ಕೇಳಲಿಕ್ಕೆ ಬರಲ್ಲ ಏನು ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಕೇಳಲಿಕ್ಕೆ ಬರೀ ಬಿಕಾಸ್ ಇಟ್ಸ್ ಮ್ಯಾಟರ್ ಇನ್ವಾಲ್ವ್ಡ್ ಇನ್ ದ ಮ್ಯಾಟರ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಈಸ್.
Make that a part of your additional objections. I'll allow the amendment application. I1 for amendment is allowed. BBMP to file its additional statement of objections, if any, in 2 weeks. Released on.
Please. Minutes,
70.
minutes, had the benefit of interim order till 12 minutes.
17 ಒಂದಿನ other ceremony ಅದಕ್ಕೋಸ್ಕರ 18 other ceremony 18
Minutes, minutes, I'm sorry, minutes, can it be on 19th minutes? Submit.
You choose the date and tell him the date.
Please. Thank you.
For further hearing, seal number 41.
FIR has been registered.
Madam, what happened to that police?
It took a little time.
No, Agil, inquiry is not complete?
It's not complete, my lord. There has been a delay from our side also, because we had to get a report from the previous commissioner to say it is not my signature. After that, they have gone and given a complaint, so FIR is registered only on 1/3, my lord. Therefore, they cannot be.
Sir, ಮಾಡಿಲ್ವಾ ನೀವು?
Copy amendment petition. That if the amended petition is given, we'll furnish everything.
Why can't you serve the notice on Aslam Pasha?
Amendment petition. The amended petition,
ಅಲ್ಲ, ಸರ್ವಿಸ್ ಯಾಕೆ ಕಂಪ್ಲೀಟ್ ಮಾಡಿಲ್ಲ ನೀವು?
we'll do that. We'll do that.
In why in this case, this kind of lethargy from the corporation?
It's in all cases in general.
Learned counsel for the municipal corporation. Municipal council.
Council.
Municipal council put up 6 for a week's time to serve the copy of the writ petition and annexures on Islam Pasha as indicated in the order dated 14/2/2025. The report of the jurisdiction sub-inspector to the effect that the investigation is still under process is taken on record. Released on 2 weeks on date.
18th.
Inform the sub-inspector madam,
Yes, ma'am.
2 weeks time ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ.
For hearing B group, seal number 42. Sri Kodandrama. B Tyagraj.
In this writ petition, sorry to mention the name, Ramanjaneya passed the order. My lord would recall that a division bench of this honorable court held that only IAS officer has to be appointed as a special deputy commissioner, and Ramanjaneya not being an IAS officer, this order is that's in incidental matter. That matter went up to, is a division bench order. That matter went up to Supreme Court. One of the parties had taken it to Supreme Court saying that I am the deputy commissioner in charge. I have not been heard. Supreme Court said she has not been heard, let her be heard. And then the Karnataka. Then this honorable court heard that matter. Then during the pendency of the writ petition before the honorable division bench, the first court, she filed a memo affidavit saying that I'm not interested in the job, I'm going out of it. I don't press this writ petition. So now that writ petition is also dismissed. This is collateral, not related to this. Now the present writ petition is filed, challenging the order of the same deputy commissioner. Grant is not cancelled. And we are now the direction is issued. A direction is issued at 136.3, transferring the name of the Kate to the government, depriving me of the land. The writ petition, I kindly see the writ petition. I'm not comfortable.
That vendor the name of the government. Several times, property has been given. They are not chosen to file objections and to produce the documents.
When the jurisdiction is questioned, that may not be significant. Yes, his non-practicing advocate filed wakalat. In the High Court also, he was absent. Then the writ petition was dismissed. The matter is recalled on the ground that the essential issues are to be considered. ಅಲ್ಲ writ petition ಒಳಗೆ ನನ್ನ ಪ್ರಕಾರ
What is your right over this land?
Well, I am the purchaser from the original grantee. 62, it was granted. The subsequent point of time,
Where is the order of grant?
this Millard documents are not produced.
ಕೊಡಿ.
ಇವಾಗ ಕೊಡ್ಬೋದಾ?
ಕೊಡಿ, ಇನ್ಯಾವ-
No plea. There's no plea. The writ petition ನೋಡಿ ತಾವು writ petition kindly land so and so the paragraph 1 grounds prayer.
Show me the documents that you have.
ತಗೊಳ್ಳಿ ಡಾಕ್ಯುಮೆಂಟ್ ತೊಗೊಳ್ತೀರಿ.
Is there an order of grant?
ಕಾಪಿ ಕೊಟ್ಟಿರಾ? Copy served on him. Page 1 grant order.
Which is the land bearing survey number?
ನನ್ನ ಪ್ರಕಾರ ತಮಗೆ ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ರಿಟ್ ಪಿಟಿಷನ್ ಒಳಗೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಬೇಕು. ಇದರಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ಸೇ ಇಲ್ಲ. And if it is called on Monday, tomorrow the application will be filed and it could come up for orders on amendment ನ ಅಲೋ ಮಾಡಿದ ತಕ್ಷಣ ನಾವು ಅಮೆಂಡೆಡ್ ಪಿಟಿಷನ್ ಹಾಕ್ತಿವಿ. ಅಂಡ್ ದೆನ್ ಈ ಅನೆಕ್ಷನ್ಸೇ ಮಾಡಿಲ್ಲ.
Who was the grantee? Muniappa.
Muniappa, it was granted in favor of Muniappa. Muniappa has executed sale deed in our favor. That is document at page 20. Mutation is done. ನಮ್ಗೆ ಯಾವ್ದು ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ರಾಮಾಂಜನೇಯ ಈ ತರ ಮಾಡಿದ್ದಾರೆ.
One nine ಅಷ್ಟೇ ಅಲ್ವಾ ಬರ್ದಿರೋದು ಇಲ್ಲಿ?
ಫೋರ್ಡ್ ಆಗಿದೆ. That has been forwarded and renumbered.
ಎಲ್ಲಿ ಸಿಗ್ತೀವಿ 119/4 ಅಂತ? ಬರೀ 119 ಅಷ್ಟೇ ಅಲ್ವಾ ಇರೋದು?
ಅದೇ 119 ಅಂತ ಮಾತ್ರ ಇದೆ. But the order may not, it is in respect of survey number 119/3.
Those things are not treated by the writ petitioner.
Where is your sale deed?
ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ಅದನ್ನ. ನಮ್ಮ ಅದಕ್ಕೆ page 20 ನೋಡಿ ಈಗ page 20. I think I thought I did not make myself clear. ಇದರೊಳಗೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹೇಳಿಲ್ಲ. ನಾನು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡುವಂತ ನನ್ನ ಅಡ್ವೊಕೇಟ್ on record I requested him and the advocate application is ready and it will be filed in the office. ಅದು ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆದ್ಮೇಲೆ ಒಂದು ರೂಪ ಬರುತ್ತೆ ಈ ಕೇಸ್ಗೆ. Now I have the order of the division bench, then the order of the Supreme Court Justice Shailendra Kumar's order decrying this particular author of this order.
But in your sale deed, there's no mention about 119/3. It only says 119.
ನಮಗೆ ಸೇಲ್ ಆದ ನಂತರ 4D ಆಗಿ ರೀನಂಬರ್ ಆಗಿದೆ. ಅದು ಆ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಕೊಡ್ತಾ ಇದ್ದೀನಿ ಈಗ ನಾನು. ಆ ಪ್ಲೀಡಿಂಗ್ ಬೇಕು ನನಗೆ.
Examine this, Manjunath. ಅವ್ರೇನೋ 4D ಆಗಿದೆ ಅಂತ verify. When do you want it?
Monday, if it could be, because I'll file the application for amendment tomorrow. ಅಲ್ಲ ನನ್ನ ಅಮೆಂಡ್ಮೆಂಟ್ ಆದ್ರೆ ಅವರು ನೆಕ್ಸ್ಟ್ ಉತ್ತರ ಕೊಡ್ಬೋದು.
Next month.
Monday.
Well.
Yes. Grateful to the honorable.
Number 43.
Filing memo of withdrawal, withdrawing the writ petition, my lord.
Number 44. Kirti Reddy.
In matter, Manjunath.
Bill number 44.
ಇನ್ನೂ ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ನೀವು petition is directed to furnish the entire list of papers to the AG free list on.
Well. Number 45.
Senior out of station, Ashok. 1 week,
From 2013.
1 week, ಊರಲ್ಲಿ.
ನೀವಿದೆಲ್ಲ ಬನ್ನಿ
Sorry, Ashok instruction.
free list.
Next week,
Next time don't ask time.
next week entry.
Well. Still number 46.
Petitioner in this case, my lord, I request the lordship to kindly grant me week's time because today I have been engaged with this petitioner with NOC. I am filing in an application also. I am filing additional application today because the important, that is the
Free list.
order of remand passed by this honorable court is not.
2013, please don't ask for
One-
time. 12 years.
I'm not ready. Next time, I'm ready. 9 days in the next week, my lord.
Well. Still number 47.
No.
Tyagaraja.
May-
Responding for petition. Senior is internal. Kindly have it on 6 or 7.
ಇವತ್ತು ಫಸ್ಟ್ ಟೈಮ್ ಅಷ್ಟ ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ಕೊಡೋಲ್ಲ. Free list.
Well.
Obliged.
Still number 48. Shri Ajit Anand Shetty.
Appear for the petition, my lords. My lords, it may kindly be passed over, my lords. My senior in other court. Grateful.
Still number 49.
The respondent. Asur.
Still number 50. Shri Arun Bhatt.
Hearing for petitioner. In this matter, withdrawing the writ petition. In the meantime, I have filed 2 applications. Legal heirs application. Petitioner number 3,
Petitions filed to bring the elders of the deceased, third petitioner, and also the application to set aside the abatement and to condone the delay. When the applications are allowed, cost rate will be amended.
I may be permitted to carry out the amendment, please, my lord.
Petitioner files seeking for permission to withdraw the application. Accepting the second cost application dismissed as well. Cost rate will be amended.
I may be permitted to file the amended petition in the registry, please, my lord.
ಮಾಡ್ಬಿಡಿ ಸುಮ್ಮನೆ.
ಇಲ್ಲಿ ಮಾಡ್ತೀನಿ, ಇಲ್ಲಿ amendment carry out ಮಾಡ್ತೀನಿ, please.
Still number 51.
Appearing for the impleading respondent.
Respondent 3 and 4, my lords.
Petition, this is a matter where the land belongs to the Defense Department. City survey record has been made, CTS number 3184. In the year 2008 and 9, the intra-party suits they make themselves, get it compromised. They make an application before the inquiry of the city survey. So he mutates to the extent of 70,000 square feet. Out of 318 was a CTS number, which was standing in the name of Defense Department. They don't have any right or interest. They filed a suit in the 2019 and they claim there is an impeding applicant. In the 2017, it's he has purchased. These are all the papers which they are trying to make up and trying to usurp the property. Property is in my possession, has been compounded. Now, the impeding application, I have filed the detailed objections with all the documents. State government was directed specifically the draft to be vetted by the Advocate General and to file the statement, whatever they have made. They claim in the year 1865, property was gifted by His Highness of Maharaja. During that period, from 1831 to 1881, it was under the control of the Britishers. And in the year 1881, there is a transfer instrument which have 1,700 acres and odd amount of land has been gifted to us, assigned. The documents have produced, my lords. I can give one small synopsis and also the additional
What is the prayer?
prayer setting aside the mutation order and confirmed by the joint director in the revision, my lords.
What was the order that you had challenged before the JDLR?
The inquiry officer's order, my lords, the mutating, my lords, here
That order.
in the writ petition, it has not been annexed in the 2016. They have annexed along with this. I place it on record with the amendment, my lords.
That's the only thing. I have kept it amendment ready. Maybe next week I place it on record minutes.
My lords, the submission, my lords, I'm for respondent number 5, my lords. My lords, this issue, this particular survey number is covered by another judgment of this honorable court, my lords, where this honorable court has specifically held that the defense is not able to show their title over the properties, and there's a similar judgment, my lords. If matter may be fixed at 2:30, my lords, then we'll definitely,
That's-
because
I
my
make,
lords,
no,
the
that's not, it is
defense, the
incorrect
petitioners
statement,
are
my lords.
dodging this
It is-
matter continuously, my
I'll
lords.
make submission
Last 6
minutes.
months.
This
They've
allowed
been
upon
taking
her.
time for the last 6 months, my lords.
Survey
My humble
number
submission is,
280.
my lords, a date may be fixed at 2:30, my lords, because the owner is about 75 years old, my lords, and she's not in a good financial state. And second, my lords, for the last 6-7 months, they have been taking time, my lords. So 2:30 may be fixed, my lords, then this is similar covered by matter, my lords. So the
No,
neighboring
no,
lands
I-
are actually decided, my
I'll
lords.
make-
Wants a time to be fixed. Yava ಮಾಡಿದ್ರಿ ಹೇಳಿ.
Next week I'll have the date. Any date.
Speak finally. Remind me on that date if you ask for time.
Yes. One more submission. I'll make minutes. All these things what they are playing is with the survey number 282. Let them place one material on record.
Argument ಮಾಡಿದ್ರೆ ಮಾಡಿ ಈಗ.
ಇಲ್ಲ, that's what I'm saying. There
Reason why my learned friend.
Absolute owner of the property by virtue of inheritance from her grandparents, 3 generations. She's about 78 years. She has no male issues. And they have threatened with men and gun on midnight, subsequent to the order of the JDL law, that the land property belongs to the owner of the property. And late midnight, they have broken the compound wall and they have attacked. And this lady is afraid to go to her own property from 2006. And subsequent to the order of it is the gifted land from the Maharaja of Mysore to her grandparents. And it is subsequently, it has been partitioned because the grantee has 2 issues and the 2 were in partition. And that partition has been successfully done. And subsequently, the JDL has called for the records. And from 2006, they don't have a single record to show that it is their property. And the similar case is ordered by this honorable court by Madam in the 777 of 2016 or so. I have produced a document to this honorable court. Similar case by Madam in case number
My lord, the.
RFA 777 of 2006. Similar case adjacent to our property was similarly occupied and harassed by the defense. The Union of India has not having a single record to show for the past 2006 to this date, my lordship, and they have taken 46 adjournments in this court just for want of a single record, which is not fair on the part of the senior citizen who is a widow, and she is suffering, my lordship, with age-old ailments and sufferings. And all the documents pertaining to this are produced before this honorable court. And my humble submission before this honorable court, my lordship. One thing, learned sir has completed his service as a counsel for the Union of India, June 2024 itself, subsequently. And I don't think even today, the records say he is not in the camp. I am sorry to bring this to the honorable court. I have the record of the honorable defense, wherein sir is appearing without record of panel in this case from 2024 June, my lordship. And this, I felt it, and I'm sorry to bring it to the honorable court. And the advocate on record, who is not in the panel, is not entitled to, supposed to appear before this court. And even I requested the chief officer of the Union of India here in Bangalore, and he said orally, and he is in the panel. But yesterday I have taken from the records of the defense, the legal forum, that Mr. M.N. Kumar is not in the panel. Do you think that is relevant for the purpose of this case? Do you think this argument should be advanced by you in this case? And
Yes, filed an application.
his client and him.
He have filed an application.
You're raising such.
My lords, this is how, sorry.
I can understand you arguing your case on merits, Why do you want to make such kind of submissions?
No, I'm sorry.
Suppose he were to make the same submission.
I requested.
Suppose he were to make the same submissions, that you don't have the wakalat. Is this something that we should go into?
The reason
Is there something that we should go into?
I'm sorry, my lordship, I'm sorry, I'm extremely sorry, because it
Right,
is.
but
He has filed Wakala, NOC Wakala, but the counsel appearing from the Supreme Court, that's the Delhi advocate, who has not given the NOC Wakala. He is representing the same client.
ಬೇಕಾಯ್ದಲ್ಲ,
My lordship. for the past-
ಬೇಕಾಯ್ದಲ್ಲ. See, this is what happens.
For the past so many
Showing
hearings,
finger to other one.
no one appeared and she.
Do you have
requested
authority to
me.
appear?
My lords, yes, my lords. My name is shown in respondent number 4, Pawan
No.
Shah.
There's another counsel appearing.
They said they'll appear for R5.
Whom do you appear for?
I'm appear. My wakal is for R4 and R5, so they had sought
Same.
permission to appear for R5. My lords, all these
Have
are
you given NOC for R5?
no, my lords.
Then-
I had not given. My lords, I'm sincerely sorry for all the confusion that they're causing, my lords. It's a simple matter, my lords. I request only for 230. I understand that they're not supposed to take those issues up.
I don't understand this at all.
And only one information, I'll bring it to your lordship notice, my lords. 2017, she claims she has sold. 2019, she filed a suit for injunction.
Minutes man ಮಾಡಂಗಿರಿ.
But
ಯಾರಾದ್ರೂ argument
next-
makes no difference.
Next week, ma'am.
But
some
I
date-
would rather that this kind of arguments are.
I don't have anything, ma'am. I make submissions on the,
As per the request of my learner
When do you
friend,
want
date may be fixed.
next week, any date, my lords.
They are saying 46 adjournment, so
It's not the case.
That's what they are saying.
So 2016, my lord, they make all sorts of allegations. I will make counter that. And apart from that, why they are making these kind of allegations also, I will make some.
ಬೇರೆ ಬೇಡ case
As
ನಡೆಸ್ತೀನಿ.
the case ನಡ್ಸ್ಕೊಡ್ತೀನಿ.
I'll put it on Thursday, get ready on Thursday.
Yes, ma'am.
By that time, you sort out this problem.
My lordship.
Whether he is interested or not, you know what is to be done.
Yes, my lordship.
He's saying he's not given NOC. If he's not given NOC, then I can't permit you to argue.
My lordship.
You know what is to be done.
Yes,
I can't take cognizance of what she says here.
Yes, my,
You know what is to be done.
Yes.
Do it by Thursday.
yes, my.
Sixth.
Grateful, my lords.
And just to confirm, my lords, he had filed an application in the suit alleging the same thing. I filed a
ಮಾಡಂಗಿದ್ರೆ
place
ನೀವು
on
ಮಾಡಿ
record.
argument
I'm
ಮಾಡಿ.
ಮಾಡ್ತೀನಿ. Next test.
Number 52, Sri D. Gangadhara.
This Thursday.
Well, could you next week ಇದು ಕೊಡ್ತೇನೆ.
ಅವ್ರು ಅಷ್ಟು ಗಲಾಟೆ ಮಾಡಿದ್ರೆ next Thursday.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಂಡಿ ಅದು ಅಬ್ಜೆಕ್ಷನ್ ಕೊಡ್ತೇನೆ, ಅಡಿಷನಲ್ ಇದು ಕೊಟ್ಬಿಟ್ಟು ಅಮೆಂಡ್ಮೆಂಟ್ ಇದು ಕೊಟ್ಟು ಮಾಡ್ತೇನೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ.
ಮಾಡ್ತಾರೆ Thursday ಅಷ್ಟೊತ್ತು ಮಾಡಿ. ಅಷ್ಟೆಲ್ಲ ನಿಮ್ಮ ಮೇಲೆ ಹೇಳ್ತಿದ್ರೆ ನೀವು.
ಅದು ಕೊಟ್ಬಿಟ್ಟು ಅಬ್ಸರ್ವ್ ನೋ ಐ ವಿಲ್ ಗೋ ವಿತ್ ಇಟ್.
Number 52, Sri D. Gangadhara.
Petitioner is? ಯಾವಾಗ?
Therefore. Last week, responded.
They stated that which petitioner is no more? ಅವ್ರ ಮಕ್ಳು ಇದಾರಲ್ಲ ಸಾಕು. First petitioner is Venkat, who's dead now? His son is there. P2, P3, P4. ಸಾಕು ಇಬ್ರಿದ್ರೆ ಸಾಕು ಬನ್ನಿ.
They have challenged Assistant Commissioner order, my lord. They have to file the appeal before the Assistant DC, Deputy Commissioner.
It's the last chance. Please stop.
Date may be.
19. So number 53, Sri Umesh Mulimani.
Responded. Forum number 7 matter, 1971 is the pen.
ಅವ್ರ ಸೀನಿಯರ್ ಇಲ್ವಾ ಅಂತ ಇವತ್ತು.
Any date please, last ಯಾಕೆಂದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ತುಂಬಾ ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ.
26th. For final hearing, number 54, Sri H.R. Ananta Krishnamurthy.
For the petitioner, Lord, in this, there's an RFA pending. It was ordered that this matter be posted after the RFA is disposed of, Lord. Yes, Lord. Lord, we also filed an application to that effect.
His properties belongs to government, my lord.
Which is that order?
My Lord, 10/3/2017, there was an order. We also filed an application, my Lord. The IA number 2.
Respondent number 5 has filed an appeal, my lord.
ಇಲ್ಲ, which is the order? Post along. Which is the date of the order? Post along with RF. Post after disposal of RFA.
My Lord, 10/3/2017.
What is RFA 656?
My lord, the RFA 656 is actually against an appeal.
Suit for bare injunction.
Injunction suit, my lord, which has been dismissed against that appeal is going ahead, pertains to the same property.
What is the order impugned here?
My lord,
What is the impugned order here?
my lord, here actually,
ACDC has
ACD
declared that
they have
is the
passed-
government property, my lord.
136.
Khata has been
Please
changed,
see.
government
136.
Khata madidare. That we have challenged. Khata has been.
How is that RFA have anything to do here?
My lord, the property originally belonged to the petitioner's grandfather, my lord, and
The
the
RFA
dispute
is
was
filed-
between tenant and this.
RFA is filed by you.
My lord,
R5.
no, my lord.
R5.
Respondent number 5.
Suppose that appeal is allowed. What is the effect of that on this order?
There are rival claimants in so far as property is concerned, both by the,
For injunction, isn't it?
so my suit was filed for injunction. And that was dismissed as against which RFA is filed.
Even if you succeed, it will be held that you are in possession.
Yes.
What is the order impugned here?
Like what happened was, after the earlier that suit came to be dismissed and an appeal came to be filed before the Assam court. The matter was remitted back to the trial court with a direction to implead the AC and DC.
What is the order impugned here?
No, after the dismissal of the suit, the revenue entries which were standing in the name of respondent number 5 was changed in favor of the state.
State, my lord.
All right.
That has been questioned in this writ
You
petition.
challenged it.
Yes, my lord.
Before
There are
the
3
AC.
writ petitions. There are 3 writ petitions.
What is his writ petition?
He is also claiming right in respect of this very same property.
So the question is whether the property belongs to the government or to any of
Yes,
his-
madam. Whether it belongs to the petitioners in the first writ petition or to the.
Suit is for declaration or for injunction?
It was filed only for bare injunction.
Then how does it matter?
But there is an order to post it after the disposal of RFA. That order may be recalled and it may be posted. I mean, the matter can be heard, madam.
On whose submission was this ordered?
ಅದು
Okay,
petitioner ಮಾಡಿದ್ದು.
Petitioner ignorance.
My lord, he subsequently filed an IA also, my lord. In 2023, IA number 2 is.
RFA 656/2016 is directed against the dismissal of a suit which was for bare injunction, in my view. This writ petition did not await the disposal of RFA 656/2016. Not counsel for the parties seek for time to address arguments. Relist on.
10 days after.
Well,
ಸಾಕ್ ಬನ್ನಿ ಇನ್ನು ಹದಿನಾರ 2016
Next week ಅಲ್ಲಿ ಯಾವಾಗ? Next week ಅಲ್ಲಿ ಯಾವಾಗ?
Thursday ಹಾಕೊಳ್ತೀನಿ.
Please.
Next Thursday. ಅಲ್ಲ ಈ Thursday.
Thursday,
ಈ
2010
Thursday.
ಹದಿನೈದು
Monday,
ವರ್ಷ.
next Monday.
None of the
ಜಾಸ್ತಿ
case.
ಮ್ಯಾಟರ್ಗಳು ಡೇಟ್ಗಳು ಫಿಕ್ಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅದಕ್ಕೋಸ್ಕರ ತೊಂದರೆ ಆಗಬಾರ್ದು.
ಎಲ್ಲ ಮ್ಯಾಟರ್ ಬಿಟ್ಟಿದ್ದು ಬನ್ನಿ ನೀವು.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ
2010 ತಾನೆ.
ಅಲ್ಲ ನಂದು 2012 ಅವ್ರದ್ದು 2010 ನೆಕ್ಸ್ಟ್ ಮಂಡೇ.
Next month. Don't ask for time again.
ಆಯ್ತು.
Seal number 55, Shri S.V. Bhatt. Shri S.V. Bhatt.
ಏನ್ ಮೇಡಮ್ ನಾನ್ ಫಿಲಿಂಗ್ ಆಫ್ affidavit by deputy commissioner and ಇನ್ನು affidavit ಹಾಕ್ಲಿಲ್ವಾ ಮನೆಯದು? I pass this order on 2/6/2022. 3 ವರ್ಷ ಆದ್ರೂ ಮಾಡಿಲ್ವಾ? The AC is filed ಅಂತ. affidavit ಹಾಕಿದ್ದಾರೆ. Who's for the petitioner?
Yes, we but.
The last chance, they list.
Tenth. Cell number 56. PM Narayan Reddy.
Yes, Lords.
Rejection of form number 7 has been challenged in this writ petition.
Where is the order?
Order at annexure A, page 19, my lords. Earlier to this proceedings, my lords, there was a proceedings under Inams Abolition Act, under section 10 of Inams Abolition Act, which is at annexure B, wherein I claim to be a tenant under this land. The Special Deputy Commissioner of Inams Abolition has held that I am an ordinary tenant under section 9A of the Inams Abolition Act. Thereafter, this application came to be filed, my lords. Initially, this application came to be allowed. My form number 7 came to be allowed on the statement of the landlord. Thereafter, that came to be challenged by the one purchaser, that is respondent number 3 to 4. Lords, they are contending to be purchased for this very same land from my landlord. And on behalf of them, they filed a writ petition. That writ petition came to be allowed and remanded back to the tribunal, my lords. The again tribunal has confirmed the order. The tribunal has dismissed my application. Thereafter, again, which was challenged by the present petitioner in writ petition, and again the writ petition came to be allowed and remanded back. Now again the similar order has been passed. My application came to be rejected. My lords, as per the rejection order of form number 7, they refers to an order, my lords, which is passed in the year 1977-78, my lords.
Please read page 20, Alva.
Page 20. At last para, my lords. ಎರಡನೇ ಎದುರುದಾರರ ವಾರಸುದಾರರು ಮಂಡಿಸಿರುವ ವಾದದಲ್ಲಿ ಅರ್ಜಿಯ ವಿಚಾರಣಾ ಅರ್ಹವಲ್ಲವೆಂದು ವಿವಾದಿತ ಜಮೀನನ್ನು ಎರಡನೇ ಎದುರುದಾರರು ಒಂದನೆಯ ಎದುರುದಾರರಿಂದ ದಿನಾಂಕ 12/12/1968 ನೋಂದಾಯಿತ ಕ್ರಯಪತ್ರದ ಮೂಲಕ ಖರೀದಿಸಿರುತ್ತಾರೆಂದು ಈ ಜಮೀನಿನ ಅಧಿಭೋಗತ್ವ ಕೋರಿ ಇನಾಮ್ ರದ್ದಿಯಾತಿ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ಮೇರೆಗೆ A5MCK 54/76/77 ದಿನಾಂಕ 2/8/1978 ಮಂಜೂರು ಆಗಿರುವುದಾಗಿ ನಿವೇದಿಸಿರುತ್ತಾರೆ. ಈ ಜಮೀನು ತನ್ನ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿ ಇರುವ ಬಗ್ಗೆ ಉಪ ವಿಭಾಗೀಯ ದಂಡಾಧಿಕಾರಿಗಳ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋರಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿ ತಿಳಿಸಿ ಅರ್ಜಿದಾರರಿಗೂ ಈ ಜಮೀನಿಗೂ ಯಾವುದೇ ಸಂಬಂಧ. This particular order, my lords, on 2/8/1978, based on this, my lords, holding that the grant which has been made in my favor in the year 1963 by the Inams Special Deputy Commissioner Inams Abolition Act has been cancelled. And by virtue of the sale deed, they are in possession of the property. But for this order, my lords, passed in the year 1978, I was not a party to these proceedings. Unilaterally, this order has been passed, my lord. That order also in challenge in this writ petition, my lords. By way of amendment.
Please read annexure B.
Annexure B, my lords. With regard to the property in question, my lords, the second, it continues.
Where is the order in your favor? You said there's an order under 9.
At annexure, annexure C, my lords.
Annexure?
C, my lords. That is in the year 23/3/1976, my lord.
This is an order by the land tribunal. Which is the order under 9A?
9A is annexure B, sorry. 9A is annexure B, my lords. Management, page 22, my lords. Page 22.
Yes.
Shri Venkat Samappa, the petitioner is stated to be in possession and enjoyment of the above 3 survey numbers.
Who are you related to Venkshamappa? Your father.
Why, please. ma'am. Enjoyment of the survey number since long time and payment of Kandayam to the Jodidar. No receipts are produced to know the exact assessment paid. Jodidars admit the claim. Hence, the above lands are registered under section 5 of the Act with a that is in respect of other survey numbers. Now, the dispute in question is survey number 17, madam. Next. The petitioner claims to be cultivating the above survey number since ancestral times on payment of Kandayam, but no receipts or other evidence, either documentary or oral, is produced. Jodidar denies the claim and says that he has given this for Vara cultivation only since 2 years. In addition, the Jodidar has claimed these lands as his Casa lands, and in case number 1039, wherein the claim of Jodidar has been upheld. As there is no documentary evidence and as the Jodidar denies the claim of Kandayam cultivation, and also in view of the fact that Jodidar admits that the land has been given for Vara since last 2 years, the petitioner is treated as ordinary Vara tenant under section 9A of the Act. And accordingly, endorsement also came to be issued in my favor as per annexure B1.
This order is not challenged.
This order is not challenged. This order is, in fact, my lord, that is what under challenge by me. They have given a petition, my lords, not exactly challenging this order. That order has been at annexure G, my lords. For which I am not the party to this order, annexure G, my lord, by way of amendment. Annexure G, my lord. It is not exactly challenging the order, but it refers to, there is no reference to particular to this order, my lords, in that order. But holds that the earlier grant is not valid.
Annexure G, no?
Annexure G, probably it may be along with my amended application. Please. Subject, occupancy rights in respect of Jodi Chakupura village, Narsapura Obli, Kolar Taluk. Survey number 5, which is a old survey number. One Chokappa, son of Nachappa Chakupura village, Narsapura Obli, Kolar Taluk, petitioned this court on 26/6/1976, accompanied by an affidavit seeking occupancy rights of the above cited survey number. He has stated in above application that he has purchased the old survey number 17, new survey number 5 of Chakupura village, Narsapura Obli, Kolar Taluk from Jodidar on 12/12/1968 by means of registered sale deed, and that ever since that date, he has been in possession and enjoyment of the same up to date. He has further stated that the second respondent, Venkatchamappa, had filed and claimed petition in respect of this said land for registering it in his name, and that from the records it is seen that the Venkatchamappa is a tenant under section 9A of the Enams Abolition Act in the year 1973, that the petitioner submitting that the said order was obtained from the Honorable Court by misrepresenting the facts of that the said Venkatchamappa has nothing to do with the land prior to the date of the sale, that is 12/12/1968, that the petitioner's father was in self-cultivation and enjoyment of the same as recited in the sale deed, and the petitioner submits that he had purchased all the rights of the Jodidar in the aforesaid land and the aforesaid sale deed, and that he is entitled to be registered as occupant under section 9 of the Act as he has entered into the shoes of Jodidar. He has also further stated that as the order and from this honorable court is illegal and the same has to be cancelled, stands honorable court and the land has to be registered in the name of the petitioner. The petitioner has prayed that he has registered under the village section 9 of Karnataka
Personal and Miscellaneous Norms Abolition Act in respect of survey number 17, new number, survey number 5 of Chakupura village by cancelling the order already made in favor of the deceased Venksamappa in support of his claim. He has adduced the following documents also. In addition to his evidence, the evidence of two Bajudars vice Muni Channappa and Muni Sonnappa of Varkeri and Suluru were examined, and they have corroborated the evidence tendered by the claimant. Peruse the records in detail. As from the records, it is proved that beyond doubt that the petitioner has purchased survey number 17, survey number 5 of Chakupura village, Narsapura Obli, Kolar Taluk from Jodidar on 12/12/1968 by means of registered sale deed, and is in possession and enjoyment of the same till day. Venksamappa, respondent number 2, has filed the claim petition in respect of the said land registered in his name. And
Assuming that this order is bad,
please, my lord.
let us assume that this order is bad.
Please, my lord.
Consequently, your order also will be bad because your order was based on the statement of the, Jodidar,
Please, my lord.
who had already sold the land.
He has already sold the land.
So if you have obtained an order
Please, my lord.
on the basis of a statement of a person who did not have title, you also can't claim any right under that.
My lord, section 9A is that, my lords, I am continued to be a tenant under him, my lord.
You will have to get that order as against the landlord.
Please, my
But
lord.
you got that order against a person who had already sold the land in 68. That order also will not bind him. Whatever argument you are advancing for this
Please,
case,
please.
your order also will suffer the same defect. How will you get over that? If I accept this argument in your case and say that this order is bad, by the same analogy, the order in your favor should also go. That is also passed without hearing the purchaser.
Purchaser.
Then
But, my lords, now that has been set aside, and with his appearance, my lord, the second order, now the present order has been passed. He
where
was a
is,
part-
where is it set aside? The order under 9A is not set aside. Your entire basis is now on the 9A order.
Please, my lord.
Because there's an order under 9A saying that you are the tenant. You are entitled to be registered as a tenant under the land.
Tenant
reform
under
act.
the, please, my lord.
If that order is bad, and if it is shown that he is a person in possession, then where do you stand?
Is not is in possession, my lords. As per section A, I am continued to be a tenant under my Jodidar.
That order will have no validity because it is passed against, is passed on the
As of
basis-
that day, he was the owner of the property.
He was
was
not
a
a party
Jodidar,
there.
please.
He was not a party there.
As on that day, the Jodidar was the, there was no
Jodidar-
sale transaction, my lord, as on that day.
No, the order that you just now read indicates the sale is of the year 68.
Please, my lord.
The order in your favor was in 73.
Not 73, it is 63, my lord, sorry. Order, annexure B is in the year 63, my lord. 61, 62. Case has been filed in the year 61, 62. Order has been passed in the year 1963, 22 September 1963, page 23, my lord. Page 23. Thereafter, he challenges how in the 68 he purchases this property. I continue to be tenant under the Jodidar. 63, my lords. My lords, in that order, they refers to 73. In the annexure G, it does not refers to 63 order.
He is now made a party in the land tribunal.
Please, my lords.
What does the land?
Now the
tribunal-
land tribunal holds that in view of this annexure G, it holds that he has purchased the property and my claim has been cancelled. 63 order has been cancelled. So he is on that basis, my application came to be rejected.
What is the revenue record stand and whose name?
Revenue record stands in his name in pursuance to the sale deed.
From 68.
Please, me.
So your name is,
70s and 1970s.
your name is not
My
there.
name is not there in, but not there in the RTC, my lord.
What is there to show that you are in possession as on 73, 74?
My lords, once 9A order has been passed, my lord, I continue to tenant. If at all they have to
Continue to tenant,
terminate tenancy, my lords, as provided in
Accept that.
26C
But
D.
the moment there is a sale deed in the year 68
Please, my lords.
and your name is deleted,
Please, my lords.
let us assume it's on the basis of the sale deed.
Please.
What is there to show that despite the sale deed, you are in possession?
No dog, except this order, my lord. There is
So
no
maybe you've
document in
accepted
my-
that 68, 63 or 68 order and kept quiet.
63.
73 order.
Please, my lords.
You accepted the order and kept quiet. Now thereafter you have revived that form number 7.
But once I am continued to tenant as per section 9A, my lords, it was incumbent on the parties to terminate my lease as provided in 26D
of the Enams Abolition Act, my lords, on the grounds enumerated therein.
But you are challenging this order after how many years?
60. My lords, we are all together contesting this form number 7A order, my lords. It was only after filing of this writ petition, my lords.
ಎಷ್ಟು ಎಕರೆ ಇರೋದು?
ಎರಡು ಎಕರೆ ಚಿಲ್ರಿ. 2
Where is
ಎಕರೆ
it?
6 ಗುಂಟೆ.
Where is it?
ನರಸಾಪುರ, ಚಕ್ಪುರ.
Who's for the other side?
The side has not appeared.
ಯಾರು ಬಂದಿಲ್ವ ಅವರು?
ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅಡ್ವೊಕೇಟ್ ರಶೀದ್ ಖಾನ್ ಅಂತ. 4 and
ಇನ್ನ ಭಾಗ ಮಾಡ್ಕೊಡ್ತೀರಾ?
we will
ಸ್ವಾಧೀನದಲ್ಲಿ
we'll
ಇದ್ದೀರಾ?
take a chance, please.
Apart from that 90 order, you don't have anything else?
No. Revenue records are not in my, 70 revenue records are in his favor, in his name.
I'm inclined to hold that he is in possession because
Lords, once there is an order under section 9A, they have to terminate, but there is no termination order. There is, without that, my lords, the Jodidar execute a sale deed in favor of
where is this sale deed?
purchaser.
Or sale deed ಇದೆಯಾ ಅಲ್ಲಿ?
Sale deed ಹಾಕಿದ್ದಾರೆ. Earlier I was practicing under Narayan Reddy, he is not keeping well, so I am arguing this matter.
Get the sale deed, let us see if both of you
Please.
can share the land.
Please,
ಒಪ್ಕೊಳ್ತಾರ ನೋಡೋಣ.
no, please.
ಅದ್ ಬಿಟ್ರೆ ಏನು ನೀವು ಸುಮ್ನೆ ಇದು 68ನೇ ಇಸ್ವಿಯಿಂದ
We are contesting form number 7A since then, my lords. This order has been challenged recently in the writ petition
ಇಲ್ಲ ಕಾಸು
by
ಇಸ್ಕೊಂಡು
seeking
ಸುಮ್ನೆ ಆಗ್ತೀರಾ?
amendment.
ಇಲ್ಲ ಕಾಸು ಇಸ್ಕೊಂಡು ಇಲ್ಲ ಕಾಸು ಕೊಟ್ಟು ಸುಮ್ನೆ ಆಗ್ತೀರಾ?
Let us have a talk to them, my lords.
Because I don't think you're in possession.
No, they are in possession of the property. Subsequently, there is some disputes and all regard to this.
ಅದೇನ ಡೌಟ್ ನಂಗೆ, ಬಟ್ ಇವತ್ತು ಬೆಲೆ ಜಾಸ್ತಿ ಇರುತ್ತಾನೆ ಇವಾಗ?
ಚಕ್ಪುರ ವಿಲೇಜ್ ಅಲ್ಲಿ ಇದೆ, ನರಸಾಪುರ ಇರತ್ತೆ. Usually, obviously, now the lands are, take a chance.
Show me the sale deed of Rashid Khan, that
Just
Rashid Khan's client,
Please,
68 sale
I'll
deed.
get typed on
Let
that.
us see what is the recital there. And find out if there's anything else to show that you're in possession. Tenth. ಇದೆಯಾ sale deed ಇದೆಯಾ?
ಸರಿಯಾಗಿ ಕಾಣಿಸೋದಿಲ್ಲ.
ಟೈಪ್ ಕಾಪಿ ಹಾಕ್ಬಿಡಿ.
Number 57, A. Keshav Bhatt.
Date, my lord. Date
10.
10.
My lord, kindly permit me to appear online, my lord.
Yes.
I am appearing for respondent in this matter.
Author was granted in the year 1972. Petitioner's father, granted in 1972. And in 82, my lord, 23/11/82, Sagwali cheat was also issued. But in 1999, after 27 years of the grant, respondent filed an appeal, my lord, challenging the grant. The deputy commissioner dismissed the appeal. Matter was taken up to the KAT and KAT remanded, allowed the appeal and remanded for a fresh inquiry. Thereafter, my lord, DC again inquired and cancelled the grant. Lord, I filed an appeal before the KAT. KAT has also dismissed the appeal. And therefore, my lord, I have presented the.
Why was it cancelled? On what ground?
My lord, the ground is, my lord, that we are not in possession and all. Actually, my lord, after 27 years, my submission is. And my lord, the main ground, I am sorry, main ground is, my lord, that it is not brought under cultivation. That is what it is. Deputy Commissioner has said. But that is also factually not correct, and there are decisions.
Is the grant cancelled on the ground that you were never in possession? Or is the grant cancelled?
But
because you-
Annexure B is the order, the present impugned order, your lordship may kindly see. The main ground is, my lord, that it has not been cultivated. But ink page 31.
Please read from page 18.
Pardon?
Page
But I shall read from my lord from
17,
17.
page
Very
18.
KET order.
KT order, point number 2.
The appeal is directed against, can I just read it?
Yes.
The appeal is directed against the, but the first is, my lord, delay. My lord, therefore I will not.
Point number 2, one is sir.
Yes. The appeal is directed against the order of R2 dated 3/2/2004. The learned deputy commissioner has cancelled the grant made in favor of the predecessor of the appellant on the ground that the land has not been brought under cultivation and the grant of the land in survey number 2011 was not proper when the land was sought in survey number 74 and 139 of Ubradka, Mitnur village. It is a fact that as a landless person, Anthony Miranda had claimed grant of land in survey number 74 and 139 in all measuring 5 acres. But the land is granted to him in survey number 2011/1 measuring 2.34 acres and 2.32 acres in survey number 2011/32. If the land claimed by the applicant was not available and if the authority wanted to grant some other available land, it was necessary for the applicant to file separate application. That has not been done. And though there was no request application for grant of land in survey number 2011/1 and 2011/3, the authorities have granted the land and this was not proper. The second respondent was justified in recording this finding. Then the coming to the other ground that the land has not been brought under cultivation, the appellants have not produced before evidence to show that they have been cultivating the land. The grant is in survey is in the year 1972. Certificate of grant Sagwali chit was issued in the year 1981. No doubt the authorities have not initiated the action against the grantee for not cultivating the land or for violation of the conditions of the grant. As per the land grant rules, the land must be brought under cultivation within a period of 3 years. And if sufficient reason exists, authority may extend the time up to 5 years. But it was only when the dispute arose between the appellants and R1, the deputy commissioner has visited the spot and noticed that the land was not brought under cultivation. The records show that on 22/3/2000.
What was the dispute between you and the
But what he
respondent?
says, my lord, that a portion of this land he had applied for grant. It was his Kumki and therefore he had applied for grant and therefore he had filed the appeal.
What was
Not to the entire land. I have produced his application. It is at annexure D.
Only one of the appellants with the KT is before this court. There were 7 appellants.
Yes.
Only one of them is before this court.
My lord, the others at that time they were not available. Therefore, I have implemented them as respondents.
Ronald Dissa is the person who is the rival claimant.
Yes. Others, my lord, they are supporting. They are brothers. My brother, there is no dispute. Ideally, they were not there. That's why I have implemented them as respondents. Only this man was there.
When was this spot inspection conducted? In 2003.
Yes.
What was the period of non-alienation when it was granted to you?
Non-alienation, my lord, I have produced the grant certificate. There is no. No, I myself is in possession. I have not alienated.
15 years then?
Yes, sir.
15 years.
38, page 38 plus
You
7.
cancel the grant after so many years? On the ground that he is not brought under cultivation? Suppose he's brought the land, he's brought the land under cultivation from 81 to 85. And thereafter is not brought the land under cultivation and is left fallow. Can you cancel it in the year 2002, 2003? No. If that period of non-alienation is only for, let us say, 15 years. Before that period, there's a violation, you can do something. After that, it becomes an absolute grant.
But I have filed it,
How can you cancel that grant unless it is obtained by suppression of material facts? He may ask for any land that he wants, but ultimately you choose to give him 211. If the conditions of the grant are not complied with, isn't there a time limit for you to take action? Can you take it up after 20 years?
May I make submission alert here?
1 minute, I'll come back. No, can that question be raised nearly 20 years after the grant? 30 years after the grant? You had the right to cancel the grant within a particular time. The only limitation that you don't have is if it's by fraud. Jilla Madam Power. Let us see the land grant rule condition.
There are three decisions actually. I have preferred a synopsis one. Short synopsis.
Yes.
One
But here, the order is more of, has created a confusion in this sense. But two survey number, that is 211/1, 2 acre 34 cents, and 211/3A, that is 2 acre 32 cents. But this is under the position of the respondents here, the contesting respondents. Insofar as these two items of properties are concerned, there was a civil suit filed against the appellant for injunction, and the court, after conducting the survey, held that the respondents are in possession of this property. Injunction was granted, as against which the appellant had filed, the petitioner herein had filed the appeal. Appeal has been dismissed. Now that has become final. So the competent civil court has held that the respondents are in possession of these two items of property. Now, the difficulty is,
when was the suit filed?
that I have filed the record before this honorable court. The suit was filed along with the memo I have filed on 10/2/2023, 6/6/2023 I have filed it.
When?
6/6/2023.
4/6/2001.
No, suit was filed 3/30/2001 was the original suit. Record I have produced before this honorable court.
OS?
Suit was filed on 11/6/2001. Decreed on
OS 43, na?
OS 3/30/2001.
3/30/2001.
When was it decreed?
Decreed on 9/4/2002.
Then appeal?
Then he has filed an appeal, which was not numbered according to me. I have that also I have produced before this honorable court. It was dismissed at the stage of the compliance itself.
Date.
Date.
This is suit for injunction.
Yes.
Yes. RA number is not there. It was dismissed on 2/8/2008.
In this suit,
Thereafter, he files an application for, makes a miscellaneous application for restoration.
Lala, 1 minute, before we go there, in this suit that you had filed for injunction.
I have sought for injunction.
correct?
Court has held that I am in possession of this property.
Did he state in that suit that land was granted to him?
My lord,
Did he take a contention in the written statement that the land was granted to him?
my lord, there, he did not file anything. He only appeared. He did not file the statement at all. He did not file the written statement.
So you did not choose to
He
say that
appeared.
the land was granted to you.
Pardon me.
You did not choose to say that the land was granted to you in the suit.
But the suit papers are not there, but it is only an injunction suit.
Maybe so. If you had indicated in the suit
Yes,
that the land was granted to you, you
Yes.
had title,
yes.
therefore you were in possession. And the trial court had recorded a finding, that is one thing. If you do not state that fact, you suffer a decree of injunction, confirmed in appeal, then you are never in possession from 2001.
My lord, that is from 72 is the grant. Merely because it
Why did you
is
not
an
say
ex
that?
parte, it looks like an ex parte decree.
You entered appearance and you wish to,
Third appearance.
that means you are not in possession, therefore.
But I will try to get a copy of the judgment, my lord. That
Produce ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, decree on produce ಮಾಡಿ.
Here ನಾನು ಹಾಜರು ಮಾಡಿದ್ದೇನೆ. I have produced before this one.
Only a decree he has produced. And only one item of the,
ನಿಮ್ಗೆ interest ಇಲ್ಲ, ನಿಮ್ಮ ಪಾರ್ಟಿಗೆ interest ಇಲ್ಲ.
Both items are there.
but only one item he had claimed to grant.
No, both items
Other,
are.
he has absolutely no title. It is a government land. Kindly see his application.
I did not file, my lord, this suit on the basis of title, my lord. I filed this suit based on that I am in possession of that property.
Madam, kindly see his application annexure.
Government land ಗೆ title ಅಲ್ಲಿ ಬರ್ತದೆ.
E. Annexure email. His application for,
You do not choose to contest the suit. You do not file written statement also.
but that I am not certain. Man.
Page number he has produced it. Though defendants 1 and 4 have appeared before the court, in spite of giving sufficient of, they have not filed written statement.
It looks like an ex parte decree, that's what I.
Expertile, you chose not to contest. And now why
My submission is.
should be unsettled this decree now, which you have suffered?
The suit is only for bare injunction.
Maybe
Question
so.
of title is not being decided. there.
He is held to be in possession by the competent civil court. Your challenge to it has been dismissed. Your application for receiving the appeal is dismissed.
And
So for the
this-
past 20 years or more,
And
he's had the benefit of a decree
But
now.
admittedly, this is a government land. Now, my lord, it has been granted in 72, my lord, after 27 years, he challenges it, that is allowed. But it is an injunction suit, he has got a decree. It is actually vacant land, my lord, nobody is cultivating as on.
The finding of the deputy commissioner is, it's naturally full of naturally grown trees.
But that, my lord,
For
this
your-
honorable court, can I just pass on this synopsis, my lord, that's all.
Everybody ಅಷ್ಟೇ ನೀನ್ synopsis ಇನ್ನೇನು?
My lord, the lordship permits.
Judgments,
You are claiming that land was granted to you,
yes,
correct?
correct.
Now, there's nothing on record to indicate that you were cultivating this land. You have suffered a decree. In the meantime, which indicates that you are also not in possession. You accepted that finding against you. In that background, the order of the appellate tribunal is justified.
My lord, may I make this concession also, my lord?
My lord, since it is a bare suit for injection, my lord, all of
Adinala
that,
bade
that,
shetra.
that is,
But
now he has no title. Absolutely, he has
you
no
will continue
title.
to be in possession.
He has
that's all.
filed a suit as against, I mean, claiming.
Even
for-
now, no, even now, if I dismiss your writ petition, you will not get title. You will only lose title. You already lost possession.
That's.
You already lost possession. You will lose title also. That is all. That is all that will happen. ನಿಮ್ಗೇನ್ ತೊಂದ್ರೆ ಆಗಲ್ಲ. ನಿಮ್ಗೇನು ಜಮೀನಲ್ಲಿ
ನಮ್ಗೆ ತೊಂದ್ರೆ ಟೈಟ್ಲ್ ಹೋಯ್ತಲ್ಲ.
ಹೋಯ್ತು, ಸ್ವಾಧೀನನೇ ಇಲ್ವಲ್ಲ ನಿಮ್ಗೆ. 25 ವರ್ಷ ಸ್ವಾಧೀನ ಇಲ್ವಲ್ಲ, ಟೈಟ್ಲ್ ಕೂಡ ಏನ್ ಮಾಡ್ತೀರಾ?
Title, my lord, possession I can take even if the once title, even
Oh.
now, my lord, I can file a suit for possession and take it.
After 25 years,
Not 25, my lord, the suit is decree, from the date of the decree,
2002,
2002.
23 ವರ್ಷ ಆಯ್ತು. Today, let the
But
matters come to
this
a
said-
rest.
May I make this submission, my lord?
Yes.
My lord, still, but in the provided, my lord, what my learned friend agrees for it or not, I don't know. There are larger properties are there in same sir. If he wants to make any claim, my lord, insofar as the remaining portion of property, except these two survey numbers, the extent which are stated in this, my lord, the decree, I still have no objection. The deputy commissioner can
I
consider.
can't go and close Martin.
This court has held in 2-3 decisions, my lord. After 5 years, my lord, it can't be
No,
cancelled.
but I will distinguish that only on the ground that you have suffered a decree 23 years ago. You can't now contend that you will be able to get possession after you have suffered the decree. ಗೆದ್ದು ಸೋತಂಗ ಆಗ್ಬಿಡ್ತಾವ್ರು 23 ವರ್ಷ ಸುಮ್ಮನೆ ಇದ್ದು.
In view of the pendency of this, my lord, he may be able to get a decree now for possession.
You accepted that is a problem.
Since it was a bare suit for injunction, that's
ಅಷ್ಟೇ ಅಲ್ವಾ?
ಅಷ್ಟೇ. ಇದೊಂದು
Dismissed.
synopsis, it will be useful now.
Submission serial number 49, my lord. It is not well. Next week.
Next time time ಕೇಳ್ಬಿಡಿ.
Minutes.
ಏನು? Who's appearing in your behalf now?
ಎಲ್ಲ ರೆಡಿ ಮಾಡ್ತೀನಿ.
58 ತಾನೆ? ನೀವ್ ಯಾರಿಗೆ? ಏನಾಗಬೇಕು? Petitioner member retirement ಹಾಕಿದ್ದಾರೆ. It is stated that Prasanna Kumar is entered appearance in place of AC Chetan. Memo retirement. AC Chetan is permanent retire. Office is directed to bring the name of Prasanna Kumar is appearing for inundation. Similarly, there is a memo retirement filed by Siddharth Sumar. Mr. Raju has entered appearance for Raju number. Siddharth Sumar is permitted.
59 that's 59 that's.
Have you informed the petitioner?
Petitioner, please.
The petitioner. Next time in the care time.
Tomorrow.
ಎಲ್ಲ ಅಡ್ಜರ್ ನಿಮ್ದೇನ್
Serial number 60, my lord, sir. Hearing for the respondent. Issue, but I have just informed.
60 ಏನು?
I appear for the respondent. Want a week's time, my lord. Not feeling well.
From next week, please don't ask time.
ಇಲ್ಲ. Great.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 58 ಅಡ್ಜನ್ ಆಯ್ತಾ? ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 58 ಅಡ್ಜನ್ ಆಗಿದೆಯಾ?
Court officer.
Court officer, sir. Sir. Court officer, sir.
B group memo ಎಲ್ಲ ಯಾವ್ದು ಕಳ್ಸಿಲ್ಲ. B group memos ಕಳ್ಸಿಲ್ಲ. ಕಳ್ಸಿಲ್ಲ. ಎಲ್ಲ ಹಳೇದಾಕ ಕೇಳಿದಾರೆ ಸಾಹೇಬ್ರು 16 ವರೆಗೂ ಮಾತ್ರ. ಐಎ ಇದ್ರೆ ಹೋಗುತ್ತೆ. ಶುಕ್ರವಾರ ಐಎ ಎಲ್ಲ ಶುಕ್ರವಾರ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
63 ನಾಳೆ ನಾನು ಲಿಸ್ಟ್ ಅಂತ
ನಾಳೆ ಒಂದು 30.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 58 ಅಡ್ಜನ್ ಆಗಿದೆಯಾ?
ಮಿಕ್ಕಿದೆಲ್ಲ ಹಿಂಗೆ
ಪಾಸ್ ಓವರ್ ಎಷ್ಟಾಗಿದೆ ಸರ್? ಹಳೆದಾಗಿರೋದೆಲ್ಲ ತೆಗ್ಬಿಡಲ್ಲ. ತರ್ಸ್ಕೊಂಡಿದ್ದೆ ಒಂದು ಫೈಲ್ ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟಿವಿ. ಅದೇ ಅದಕ್ಕೆ ತೆಗ್ಬಿಡ್ತೀನಿ ಇವಾಗ.
ಸರ್?
ನಾಳೆ ಈಗ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
58 ಬರುತ್ತಾ? 58 ಸೀರಿಯಲ್ ನಂಬರ್.
58 ಸೋಮವಾರ ಬರುತ್ತೆ.
ಸೋಮವಾರ ಬರುತ್ತೆ.
ಗುರುವಾರ ಮಾಮೂಲಿ ಇದ್ರೆ ಮಾತ್ರ ಅದೇ ಹೇಳಿದ್ದಾರೆ. ಚೆಕ್ ಮಾಡ್ಕೊಟ್ರು 16ವರೆಗೂ ಅದೆಲ್ಲ ಹೊಡೆದಾಕಿದೆ. ಎಲ್ಲಾದ್ರೂ ಅಷ್ಟೇ ಏನು ಇರೋದೇ ಗುರುವಾರ
ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ
ಸರ್. ಬಿ ಗ್ರೂಪ್ ಬರೀ 2016 ವರೆಗೂ ಹಾಕಕ್ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅದಾದ್ಮೇಲೆ 1-2 ವೀಕ್ಸ್ ಆದ್ಮೇಲೆ ನೋಡ್ಬೇಕು
ಸರ್. 57 ಆಗಿದೆ, ಈಗ 58 ಮತ್ತೆ ಬಂದು ಕರೀತಾರ ಸರ್?
ಆಯ್ತಲ್ಲ ಅಡ್ಜರ್ನ್ಮೆಂಟ್.
ಅಜ್ಜನ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 57 ರಿಸರ್ವ್ ಆಯ್ತಾ ಅಥವಾ ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತಾರೆ ಸರ್?
ಅದೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು ಸರ್. ರೀಸನ್ಸ್ ಟು ಫಾಲೋ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 61 ಇದೆಯಾ ಸರ್?
ಇದೆ ಮೇಡಮ್.
ಓಕೆ ಸರ್.
ಡಿಸ್ಮಿಸ್ ಹೇಳಿ. ಡಿಸ್ಮಿಸ್ ಅಷ್ಟೇ. ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ವಿಶ್ವ ಬಟ್ಟೆ ಮಾಡಿದ್ದಾರೆ. ಸರಿಯಾಗಿ ಮಾಡಲ್ಲ. ಏನ್ ತೋರಿಸಿದ್ರೆ ಅಲ್ಲ, ಕೆ ಶಿರೀಶ್ ಕೃಷ್ಣ ಇವ್ರದ್ದು ಯಾರು ಆಗಿರುತ್ತಾ ಚೇಂಬರ್ ಡೇಟ್ ಅಲ್ಲಿ 11th ಬ್ಯಾಡ್ ಐತೆ.
Merit one submission merit. Serial number 60, I am told that it is adjourned to 11th of this month, my lord. Kindly I will talk to 12th, my lord. Some inconvenience is seen on 11th, 12th, my lord.
ಅಲ್ತಾ
12th month.
14th. Passed over matter. Seal number 48.
Petition is by,
Proposing you.
that's Mr. Ariga is opposing.
I was here when the case was called, first round.
ಅಲ್ಲ ಬೆಳಿಗ್ಗೆ ನಾನು ಇರ್ಲಿಲ್ಲ.
ಅವರಿದ್ರು
ನಾನು ಕಾಯ್ತೀನಿ, I'll wait. My only contention, Lord, is that it's an order against a dead man. The death of the person who was arrayed as a landlord was informed, my lords, to the tribunal.
next year, why?
Why is the order, my lords? Why is the order? But if my lords were to,
You are the tenant.
lords, I'm the landlord. I'm the landlord. And as per the impugned order, my lords, the occupancy rights have been granted. My lords would find the observation, lords, at page 111.
Yes.
My lords has. ಆದೇಶಕ್ಕಿಂತ 2 ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೇಲೆ ನ್ಯಾಯ ಮಂಡಳಿಯ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸದ್ರಿ ಜಮೀನು ಮಂಜೂರಿದಾರರ ಸ್ವಾಧೀನತೆಯಲ್ಲಿಯೇ ಇರುತ್ತದೆ. 1/3/1974 ನಿಕಟಪೂರ್ವದಲ್ಲಿಯೂ ಸ್ವಾಧೀನತೆ ಹೊಂದಿರುತ್ತಾರೆ ಎಂದು ರುಜುವಾತುಗೊಂಡಿದೆ. ಕಡತದಲ್ಲಿನ ಪರಿಶೀಲಿಸಲಾಗಿ ಎಲ್ಲಾ ನಂಜ ಜಮೀನುಗಳಾಗಿದ್ದು ಗೇಣಿ ಜಮೀನುಗಳೆಂದು ದೃಢಪಡುತ್ತಿದೆ. ಅರ್ಜಿದಾರರು ಮೆಮೊ ಸಲ್ಲಿಸಿ ಅನಾದಿ ಕಾಲದಿಂದಲೂ ತಾವೇ ಸ್ವಾಧೀನತೆ ಹೊಂದಿ ಅನುಭವಿಸಿಕೊಂಡು ಬಂದಿರುತ್ತೇವೆ. ಚಾಲ್ಗೇಣಿ ನೆಲೆಯ ಜಮೀನಾಗಿದ್ದು ಮಂಜೂರು ಮಾಡುವರೇ ಕೋರಿರುವುದಾಗಿದೆ. ಅರ್ಜಿದಾರರ ಹೇಳಿಕೆ ಹಾಗೂ ಕಡತದಲ್ಲಿರುವ ದಾಖಲೆಗಳ ಆಧಾರದಲ್ಲಿ ಚಾಲ್ಗೇಣಿ ಜಮೀನಾಗಿತ್ತೆಂದು ರುಜುವಾತುಗೊಂಡಿದ್ದು ಸರ್ವೆ ವರದಿಯಂತೆ ಅರ್ಜಿದಾರರು ಸ್ವಾಧೀನತೆ ಹೊಂದಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯನ್ನು ಸತ್ಯತೆ ಮತ್ತು ನೈಜತೆಯಿಂದ ಕೂಡಿರುವುದರಿಂದ ಅವರ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಭೂನ್ಯಾಯ ಮಂಡಳಿಯಲ್ಲಿ ಚರ್ಚಿಸಿ ಒಮ್ಮತದಿಂದ ಅರ್ಜಿದಾರರಿಗೆ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ ಸೋನ್ಸೋ ಸೆಕ್ಷನ್ ಸೋನ್ಸೋರನ್ನು ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿದೆ.
You were represented by a counsel?
My lords, I was not represented by a counsel. May I just trouble my lords with the order sheet, the relevant dates, page 66. If my lords were to kindly peruse page 66, ink page 66. That would be, my lords, page 18 of the order sheet. My lords, if my lords, I'll just read out 28th May 2011. ಪ್ರಕರಣ ಕರೆಯಲಾಯಿತು. ಅರ್ಜಿದಾರರು ಹಾಜರು. ಎದ್ರಿ ಮೃತ ಅವರ ತಮ್ಮ ಮೊಹಮ್ಮದ್ ಜುಬೇದ್ ಹಾಜರು. ಇವರು ತಿಳಿಸಿರುವಂತೆ ಅರ್ಜಿದಾರರು 1 ವರ್ಷದ ಹಿಂದೆ ಅವರ ಪತ್ನಿ ಸುಮಾರು 13 ವರ್ಷಗಳ ಹಿಂದೆ ಮರಣ ಹೊಂದಿದ್ದು ಅವರ 5 ಮಕ್ಕಳು ಇರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಅವರ ಮಕ್ಕಳು ಮತ್ತು ತಮ್ಮೆಲ್ಲರ ಸಹೋದರ ಸಹೋದರಿಯರ ಅಧಿಕಾರ ಪತ್ರ ತನ್ನಲ್ಲಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. So and so, so and so. Then my lords were to turn over leaf, not page 68.
So he represented you?
There is a recording that my paternal uncle appeared before the tribunal.
But he also says that he had the power of attorney.
That's what it says, but then page 68, if my lords were to see for a moment, 24th January 2012, it says, ಪ್ರಕರಣ ಕರೆಯಲಾಯಿತು. ಅರ್ಜಿದಾರರ ಸೋ ಅಂಡ್ ಸೋ ಇವರೆಲ್ಲ ಹಾಜರು. ಪರವಾಗಿ ನ್ಯಾಯವಾದಿ YMS ಹಾಜರು. ಎದ್ರಿ ಹಾಜರಿಲ್ಲ. ಅವರಿಗೆ RPID ನೋಟಿಸ್ ಸಂತತಿ ನಕ್ಷೆ ಪಡೆಯುವುದು ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋಕ್ಕೆ ಮುಂದೂಡಿದೆ. Our specific contention is that no notice was ever
not issued, nor was it served on us. And eventually, my lords, the order is passed on a dead man.
ಅವ್ರು ಯಾವ್ದು objections ಯಾವ್ದು raise ಮಾಡಿದಾಗೆ ಇಲ್ಲ. I kindly see the order, paragraph 2 of the order.
At page 66, there is a recording of the fact that the landlord is dead. His brother makes a statement
ಅಲ್ಲಿ
at page 66. Type page 18 of the order sheet.
Oh, good. Here I. One second.
Page 8.
Yes. 16/7/2011 ಅಲ್ಲಿ internal page 90 16/7/2011 ಪ್ರಕರಣ ಕರೆಯಲಾಯಿತು. ಅರ್ಜಿದಾರರು ಹಾಜರು. ಎದ್ರಿ ಮೃತ. ಅವರ ತಮ್ಮ ಜುಬೈದ್ ಹಾಜರು. ಎದ್ರಿಯರ ಮೊಹಮ್ಮದ್ ಅಹಮದ್ ಕಾಜಿ ಇವರ ಮರಣ ದೃಢಪತ್ರ. ಅವರ ಪತ್ನಿ ಬೇಬಿ ಆಯಿಷಾ ಇವರ ಮರಣ ದೃಢಪತ್ರ ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ಇವರ ವಾರಸುದಾರರ ವಿವರಗಳನ್ನು ಮತ್ತು ಅವರ ಬಗ್ಗೆ ವಕಾಲತ್ತು ಸಲ್ಲಿಸುವುದಾಗಿಯೂ ತಿಳಿಸಿರುತ್ತಾರೆ. ಎದ್ರಿ ಅವರಿಗೆ 6 ಜನ ಮಕ್ಕಳಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು, ವಿವರ ಒದಗಿಸಿದ ನಂತರ ರಾಜಿ ತೀರ್ಮಾನ ಮಾಡುವುದಾಗಿಯೂ ತಿಳಿಸಿರುತ್ತಾರೆ. ದಿನಾಂಕ 4/10/2011 ಅರ್ಜಿದಾರರ ಎದ್ರಿಯರ ಕೋರಿಕೆ ಮೇರೆಗೆ ಪ್ರಕರಣ ಮುಂದೂಡಿದೆ.
ಏನ್ ರಾಜಿ ಅಂದ್ರೆ ವಾಸ್ ಇಟ್ ಸೆಟಲ್ಡ್?
ಇಲ್ಲ ಅಲ್ಲಿ ಆರ್ಡರ್ ತಾವು ದಯವಿಟ್ಟು annexure Y ನೋಡಿದ್ರೆ annexure Y is the impugned order by the land tribunal.
Yes.
Paragraph 110.
There's nothing here which indicates about the death. It simply proceeds on the merits of the matter.
ಅಲ್ಲಿ paragraph 2 right hand side first part. ನ್ಯಾಯ ಮಂಡಳಿಯ ಆದೇಶದ ವಿರುದ್ಧ ಪ್ರತಿವಾದಿಯವರು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ WP 27/542/92 ದಾಖಲಿಸಿಕೊಂಡು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು 22/9/1991 ತನ್ನ ಆದೇಶದ ಭೂ ನ್ಯಾಯಮಂಡಳಿಯ ಆದೇಶವನ್ನು ರದ್ದುಗೊಳಿಸಿ ಮರು ತನಿಖೆಗೆ ಕಡತ ರವಾನಿಸಿರುವುದಾಗಿದೆ. ಭೂ ನ್ಯಾಯಮಂಡಳಿಯು ಪ್ರಕರಣವನ್ನು ಮರು ವಿಚಾರಣೆಗೆ ಒಳಪಡಿಸಿ ಪಕ್ಷಗಾರರಿಗೆ ನಮೂನೆ 9D ಯಲ್ಲಿ ವೈಯಕ್ತಿಕ ನೋಟಿಸು ಜಾರಿ ಮಾಡಲಾಯಿತು. ದಿನಾಂಕ 7/1/2003 ವಿಚಾರಣೆ ಪ್ರಾರಂಭಿಸಿ ಕಾಲಕಾಲಕ್ಕೆ ಮುಂದೂಡುತ್ತಾ ಬಂದು ಈ ದಿನ ಅಂತಿಮವಾಗಿ ತನಿಖೆಗೆ ಕೈಗೆತ್ತಿಕೊಳ್ಳಲಾಯಿತು. ಅರ್ಜಿದಾರರ ಪೈಕಿ ಸೋ ಅಂಡ್ ಸೋ ವಕಾಲತ್ತು ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಎದ್ರಿದಾರರು ರಾಜಿಗೆ ಸಿದ್ಧರಿದ್ದೇವೆ ಎಂದು ಸಹ ಭೂ ನ್ಯಾಯಮಂಡಳಿಯ ಮುಂದೆ ಹೇಳಿದ್ದಾರೆ. ಆದರೆ ಯಾವುದೇ ಆಕ್ಷೇಪಣೆ ಹೇಳಿಕೆ ಹಾಕಿಲ್ಲ. ತದನಂತರ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಸ್ಥಗಿತಗೊಂಡಿದ್ದು ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಪುನಃ ಕಾರ್ಯಾರಂಭವಾದ ಕಾರಣ ದಿನಾಂಕ 28/6/2010 ವಿಚಾರಣೆ ಪ್ರಾರಂಭಿಸಲಾಯಿತು. ಎದ್ರಿ ಅವರ ಪರ ಅವರ ತಮ್ಮ ಜುಬೈದ ಹಾಜರಾಗಿದ್ದಾರೆ. ಆದರೆ ಯಾವುದೇ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿಲ್ಲ. ಪ್ರತಿವಾದಿ ಅರ್ಜಿದಾರರ ವಾರಸುದಾರರ ಲಿಖಿತ ಸಾಕ್ಷಿ ಹೇಳಿಕೆ ದಾಖಲಿಸಿದೆ. ಪಾರ್ಟಿ ಸವಾಲಿಗೆ ಪ್ರತಿವಾದಿ ಹಾಜರಾಗಿಲ್ಲ. ಪ್ರತಿವಾದಿಗೆ ಆಸಕ್ತಿ ಇಲ್ಲವೆಂದು ಪರಿಗಣಿಸಿದೆ. ಅರ್ಜಿದಾರರ ವಕೀಲರು ವಾದ ಮಂಡಿಸಿದ್ದಾರೆ. ಸರ್ವೆ ವರದಿಯಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿ ಸ್ವಾಧೀನತೆ ಬಗ್ಗೆ ಹೇಳಲಾಗಿದೆ ಎಂದಿದ್ದಾರೆ. ಅಂತೆಯೇ ಅರ್ಜಿದಾರರಿಗೆ ಅಧಿಭೋಗದ ಹಕ್ಕು ನೀಡಿ ಆದೇಶ ಮಾಡಬೇಕೆಂದಿದ್ದಾರೆ.
But that means he accepts the fact that he was dead.
ಹೌದು. ಆದ್ರೆ ಏನಾಗಿದೆ, ಇದೆಲ್ಲ ನಂಜ ಭೂಮಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಎಲ್ಲ ಟೆನೆಂಟೆಡ್ ಲ್ಯಾಂಡ್ ಆಸ್ ಆನ್ 1374 question.
What is the ರಾಜಿ ಮಾಡ್ಕೊಂಡೆ? What is the meaning of that?
ರಾಜಿ ಅಂದ್ರೆ ಇದು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ತಾರೆ ಅಂತ.
ರಾಜಿ ಆಗಿತ್ತ?
ಅದು ಗೊತ್ತಿಲ್ಲ ನನಗೆ. ಇಷ್ಟು ಮಂದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ. There is no response at all because matter is coming up.
Have to send it back, isn't it? I'll have to send it back. I can't,
ಮತ್ತೆ ಸರ್ವೆ ವರದಿ ಅಂತೂ ಅರ್ಜಿದಾರರ ಸ್ವಾಧೀನ.
not in the merits. They did not have an opportunity to.
ಏನಾಗುತ್ತೆ
If
ಅಂದ್ರೆ
there is a settlement, then if you are still agreeing to the settlement, then maybe matter can be closed here. I don't know what is the terms of the settlement.
ಅದು he
Indicate there
also-
was some settlement.
ಇಲ್ಲ ಮಾತಾಡ್ಬೋದು ಸರ್, ಬಟ್
Because if I send it back now, already I think 30 years have lapsed. For the notices to be complete, it will take another 3 to 4 years.
it may submit this note. ವಾಸ್ತವಾಂಶ ಇದೆ. Notes, my clients were not the actual landlords. They had purchased this property. The applicants were all coolies, not agricultural laborers who were.
What is your expectation? Without going to the merits, what is it that you want from them? Are you looking for any monetary compensation or what exactly?
ಅಲ್ಲ ಇದು ಆಲ್ಮೋಸ್ಟ್ 30 ಎಕರೆ ಇದೆ ಸರ್. ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಶೇರಿಂಗ್ ಏನಾದ್ರು ಮಾಡೋಂಗಿಲ್ಲ.
If it's already divided, then where is the question of you butting in now?
I'll
Take some money and close the matter.
ಅವ್ರಿಗೆ they may not be in such a position. They are from also from a lower strate of society. ಅವ್ರಿಗಷ್ಟು ಹಣಕಾಸಿನ ಸೌಲಭ್ಯ ಇಲ್ಲ ಅಂತ ಕಾಣ್ತದೆ.
Then you, what is the point? If I send it back, for the next 20 years, I'm sure will same position.
ಇಷ್ಟು
For you to
ಮಂದಿಗೆ-
ಅಲ್ಲ ನನ್ನ
ಮಂದಿಗೆ ಸರ್ವ್ ಆಗ್ಬೇಕಾದ್ರೆ ಆಗ
And by the time, all of them would have died.
in fact, when the petition started, there were around 10 petitioners. ಅದ್ರಲ್ಲಿ ಅರ್ಧಕ್ಕರ್ಧ ಅವರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. ಅವ್ರಿಗೂ ಹೇಳಿದೀನಿ ನಾನು. ಆದ್ರೆ ನೋಟ್ಸ್ there is some difficulty notes. ನಾನು notes I've tried. In fact, my senior friend Malot also had helped me in certain extent, to certain extent. ಪ್ರಯತ್ನ ಮಾಡಿದೀವಿ, ಇಲ್ಲ ಅಂತಲ್ಲ. ಇನ್ನೊಮ್ಮೆ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ, ನಾವು ಹೇಳಿದ್ರೆ ಇನ್ನೊಮ್ಮೆ ಮಾಡ್ತೀವಿ.
Or else I have no other option but to send it back and till 2035, you will still be there only with the land tribunal.
That is true.
And again come back, again wait up to 2050.
This is already not third round. ಮೂರನೇ ರೌಂಡ್ ಇದು. ಅದು ಹೇಳಿದೀನಿ, ಎಲ್ಲ ಹೇಳಿದೀನಿ. ಕೆಲವು ಕಕ್ಷಿದಾರರು ಮಾತು ಕೇಳಲ್ಲ.
I will try, because for 2 persons out of them are in touch. That is, one is Padmaksha Pujari and Manjunatha Pujari. I called them, I wrote 2 or 3 letters to them and also to their counsel. They said they will come. That is about 3 weeks back when the matter was listed. We will make a try, not more than 5-6 days, I think. Otherwise, matter has to go back. That is also.
I don't mind saying it right now, but I don't see the benefit you will enjoy. I don't think you will get any benefit.
Because my clients are in possession.
ಎಲ್ಲ implications ನಾನು ಹೇಳಿದೀನಿ. I have explained the entire ambit of.
If it is not agreeable, let's send it back. Holy budi ಒದ್ದಾಡ್ಕೊಂಡು. Why should I?
What's
ಆಗ್ಬೋದು.
The petition is filed challenging an order of the land tribunal, by which the tribunal has conferred occupants' rights on the tenants. It is the case of the petitioner, who is the landlord, that though the land tribunal recorded the fact that the landlord, Muhammad was no more, and his brother, who had appeared with the tribunal, informed the tribunal that he had left behind him 5 children. Nevertheless, the tribunal has proceeded to pass an order which, against a dead person, it is pointed out by learned counsel appearing for the tenants that the tribunal was compelled to pass the order since there was no representation of behalf of the respondent and there was no contest to the applications filed by the tenants. The perusal of the order sheet indicate that on 28/5/2011, the land tribunal was informed about the death of the landlord Muhammad Ahmad, and this information was given to it by the brother of the deceased landlord, who also informed them that he had left behind 5 children. The subsequent order dated 16/7/2011 also indicates that the matter was adjourned to enable the details of the LRs would be furnished and efforts would be made for their effective representation. Ultimately, however, the order sheet dated 24/1/2012 merely indicates that the notice was sent by RPAD and the same was returned. These facts would therefore indicate that the order is passed by the tribunal knowing fully well the landlord was dead and had left behind 5 children as his LRs. It is set law that no order can be passed against a dead person. In that view of the matter, the impugned order is set aside and the matter is remanded to the land tribunal for fresh consideration. The land tribunal shall notify all the parties concerned and decide the matter afresh.
Right. 61, Srimati Vidya.
Yes. What is annexure B? You are for? Petitioner, lady or check? Petitioner, lady or check?
Then her son Gopalappa was the architect of the temple. Now her granddaughter, that is the petitioner during the class. In fact, this passenger report is submitted to responsibility to the access to the immediate the deputy commissioner has sought for the list of temples along with
No, can she be a nurture? A lady can be a nurture? I have not come across any lady as such. You have seen them? What is that? You? Solution. Why is it now rejected? Uncle is your father's brother.
Challenging that one, ND Krishnamurti had challenged it before the council. Matter came to be remanded. After it was remanded, the matter is transferred to the revision. Now, ND Krishnamurti evidence has been narrated as against him before the respondent. One, Lakshmi Raman was respondent of court. She claims to be the wife of C.H. Krishnamurti. C.H. Krishnamurti was unmarried. That is our specific case. We have stated that before review comes to our without conducting an inquiry because he is in favor of C.H. Krishnamurti. Occupancy rights were initially granted. She claims to be the wife. She has been given occupancy.
No, she has basically succeeded to the rights of her husband. Or according to her, her husband was the archer.
Yes.
She is only the legal heir of B.S. Krishnamurti. And your case is that she is not the LR. What? No, but your father never made the application for grant of occupancy rights. Because only if your father had made the application for confirmed occupancy rights, can you claim to have succeeded to his right? If your father has not made the application as an archer, can his daughter make an application? No, if he had made the application on behalf of the family and on his death,
No inquiry with respect to that is conducted. She has not produced any documents also. Your lordship may kindly be annexure to last, in page 17.
Read from para 7.
ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಒಂದನೇ ಅಧಿಕಾರದ ಬಿಡುತ್ತಾರೆ. ಅವರ ವಾರಸುದಾರರಿಗೆ ಪ್ರಕರಣದಲ್ಲಿ ಸರಳ ಕಾಲವನ್ನು ಬಳಸಿ ಉಪಯೋಗವಿರುತ್ತದೆ. ಎರಡನೇ ಅಧಿಕಾರರಾದ ಮಧ್ಯಮ ಸಂಸ್ಥೆಗೆ ದೇವಸ್ಥಾನದ ಆಸ್ತಿಗಳಾಗಿದ್ದಾರೆಂದು ಅವರ ನಂತರ ಅವರ ಮೊದಲಾದ ಕಾಲದಿಂದ ನೆರವೇರಿಸುತ್ತಿರುತ್ತಾರೆ. ಇನಾಮಿ ಜಮೀನಿನ ಅನುಭವಕ್ಕೆ ಜಮೀನಿನಲ್ಲಿ ಸಾಗುವಳಿ ಮಾಡಿರುವುದಕ್ಕೆ ದಾಖಲೆಯ ಬೇರೆ ದೇವಸ್ಥಾನದ ಕಾರ್ಯವಿಲ್ಲ. ಇವರು ವಿವಾದಿತ ಜಮೀನುಗಳನ್ನು ಸಾಗುವ ಅನುಭವಕ್ಕೆ ಯಾವುದೇ ದಾಖಲೆ ಇರುವುದಿಲ್ಲ. ಮರಳಿ ಸಾಗುವ ನ್ಯಾಯ ಮಂಡಳಿಯು ದಿನಾಂಕ ಕೈಗಾರಿಕೆ ಪುಸ್ತಕಗಳನ್ನು ಹೊರಡಿಸಿದ ಆದೇಶದಲ್ಲಿ ಅವರಿಗೆ ಅಧಿಭವತ್ವ ಮಂಜೂರು ಮಾಡಿರುತ್ತದೆ. ಈಗ ಸದರಿ ಕೃಷ್ಣಮೂರ್ತಿ ನಿಧನರಾಗಿರುತ್ತಾರೆ. ನಾಲ್ಕನೇ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮೀದೇವಮ್ಮ ಕೃಷ್ಣಮೂರ್ತಿಯವರ ಪತ್ನಿಯಾಗಿದ್ದು ಆಕೆಯ ಮೂರನೆಯ ಅರ್ಜಿದಾರರ ನ್ಯಾಯಬದ್ಧ ವಾರಸುದಾರರಾಗಿರುತ್ತಾರೆ.
So the first order was granted in favor of B.S. Krishnamurti. You did not challenge that. No. Where is your application? I don't think if your father had not made the application, or if you had not made the application saying that my father was the archak and as a consequence he was cultivating the land, you cannot come in the middle and say that give the land to me. File a suit for partition. No, then why don't you file a suit for partition saying that she should not have been granted the occupancy rights? I am the only sole surviving legal heir for the entire family. Therefore, you are entitled for the entire property. If this order goes, then the property continues to be vested with the government, isn't it? No, I'm questioning your locus standi. If you have not made an application, if your father has not made an application, can you question the grant of occupancy rights in favor of somebody, your uncle? Where is this application? You have a copy of the application? Records ಇದೆ ಬನ್ನಿ. What is your client's name? Think you're just annoyed that it went to your auntie. Where are you residing? No, that's what you will say. Where is the land? In Nagpura. And where are you residing? You are married and residing somewhere else. So how can you be in possession? ಲಕ್ಷ್ಮೀದೇವಮ್ಮ ನಾಗ್ಪುರ ಅಂತಾನೆ ಇದೆ. ನೀವ್ ಯಾವ್ದೋ ಬೇರೆ ಊರು. Krishnamurthy is Upparalli, you are Baleganalli. You are married and obviously could not have been in possession. How can you be in possession now? And you made the application for conferment after the land tribunal had set aside the order in favor of M.K. Krishnamurthy. Your application came out in the year 87. So your father never made the application. Boss mana bani itkolli bidi ni matke tane ಅವರು. No LRs for her? Then when did she die? You're not there. You're not there. She is not there.
Yeah, please. Yes, teaching.
Notice was served through paper publication. Yeah, no, they are residing in Kolar and you're taking out publication Vijay Karnataka. They were residing in Malur. You have taken out notice on Vijay Karnataka, which is published in Bangalore. What did the notices come back as? Petition is filed challenging the order of the Special Deputy Commissioner who has conferred occupancy rights on Lakshmidevamma, the deceased fourth respondent. It is a case of the petitioner that the lands in question were endowed to Sri Venugopal Swami Venugopal Swami temple, to which our ancestors were the Archaks. It is her case that after her father passed away, she was doing the Archakship of the temple. It appears that the land tribunal had passed an order on 25/8/1981, granting the occupancy rights in favor of B.S. Krishnamurthy, who was the paternal uncle of the petitioner, that is her father's brother. However, this order was challenged by M.K. Krishnamurthy in WP number 28293/81. And this court had set aside the order passed in favor of B.S. Krishnamurthy and remanded the matter for fresh consideration. So, on remand, it was noticed that the writ petitioner, that is M.K. Krishnamurthy, was no more, and steps had not been taken to bring his LRs on record. Consequently, the proceedings that he had initiated stood awaited. From the pendency of these proceedings, the petitioner herein had also made an application for conferment of occupants' rights on 11/6/87. It was on 6/6/1981. It was one of the contentions of the petitioner that our uncle, B.S. Krishnamurthy, was unmarried, and therefore the claim by the fourth respondent, Lakshmi Devamma, could not be entertained. The tribunal in the impugn order has not considered this aspect of the matter. It has merely gone on to state that there was nothing produced to show that the petitioner therein was in possession of the lands in question. Learned Counsel points out that if Lakshmi Devamma was not the wife of B.S. Krishnamurthy, then by virtue of succession, she would have succeeded to the property and not Lakshmi Devamma. In my view, this is an argument which ought to have been considered by the tribunal before it passed the impugn order. It is to be noticed here that the question as to whether Lakshmi Devamma was the wife and was entitled to succeed to the interests of B.S. Krishnamurthy was also called in question by the petitioner. And since the petitioner was claiming to be the daughter of B.S. Krishnamurthy's brother, the tribunal ought to have considered, the specialist ought to have considered this matter before passing an order. The impugn order is therefore set aside and the matter is remanded to the Special Deputy Commissioner to reconsider the matter afresh. The Special Deputy Commissioner shall also take into consideration and determine as to whether Lakshmi Devamma is the legal heir of B.S. Krishnamurthy or not. If it is accordingly allowed. I'm not saying anything. I'm only saying that your contention is that she is not the wife. So if she is not the wife, then automatically B.S. Krishnamurthy is right, you will get. That I have my doubts whether he will be. Now then, by virtue of being the Archak, lands are endowed to the temple. You are allowed to cultivate. Then the question is whether you have proved that possession. If you have not proved that possession, then your application is, if your father had made the application, yes, you could have continued that. But if you have not produced any document to show that you are in possession, I have my doubts whether I can entertain that claim. So it's better that you go on this line. If she is not the wife, then you will automatically get. Either way, B.S. Krishnamurthy will get the property. Both of you can fight and maybe the settlement where you can share the property or something. Reminded these questions.
So number 62, Shri Arike.
Records were called for.
In order.
Land tribunal order, my lord. What they say is that all members had not signed the orders. What?
You tenant the landlord.
Tenants petition.
Your application is rejected. Sign madilvaru?
ಇಲ್ಲ ಇಬ್ರು ಮಾಡ್ಲಿಲ್ಲ. And the matter was posted for cross-examination. At that time, an IA came to be filed. Heard IA and matter is disposed of.
That I have my arguments on that, my lord. Therefore, I wanted to look through this. Two aspects, my lord.
Like even assuming the signature quorum madidru anta, if the application that is filed according to him.
I will submit even on that, my lord. On that aspect, my lord, this is third round of litigation, matter is remanded. 3 times evidence has been led by them. And then we have also led the evidence. At this stage of evidence, my lord, we have led our evidence and on the cross-exam on 2 occasions, 3 dates, they have taken the taken time, adjournment has been taken. So on 6 dates after we have been examined, RW1 is examined, the matter has been listed. Then, my lord, they file application for spot inspection. Spot inspection has been rejected on 2 occasions. First by the ALRA and the second occasion by the very same tribunal when the matter was there in the beginning of the proceedings. Now, what was the reason for them to file an application again, a rejected application, not challenged before the petition on the High Court? Second time before the same authority they have to file. That means they have no further evidence. Then
Fact remains that matter was not set down for their evidence.
at that time, they filed the application. That application was heard and rejected. Now, 18/7 was rejected.
Thereafter, were they given a chance to adduce evidence?
ವಿಚಾರಣೆಗೆ ಅಂತಿದ್ರೆ ಅವ್ರು ಮಾಡಲಿಲ್ಲ ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಲಿಲ್ಲ. Then what happened, my lord? We advanced the matter and filed our written arguments has been filed. On that day, our arguments have been heard. They also were there, they were present. Then when the matter was rejected.
From whatever you told me, even then, they were not given opportunity to adduce their evidence.
Opportunity was not, when the matter was listed again, my lord, they did not say vicharane.
What was the urgency for you to get it preponed?
We wanted to file our written arguments, my lord. My lord, may I take your lordships to the.
And if 2 members have not signed, it sends a different.
Place, my lord, tomorrow your lordship.
ಇಲ್ಲ ವಾಪಸ್ ಕಳಿಸ್ಬಿಡ್ತೀನಿ ಅಲ್ಲೇ ಹೋಗ್ತಿರ್ಗ.
ವಾಪಸ್ ಕಳಿಸೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, ಏನಕ್ಕೆ ಅಂತ ನಾನು ನಿಮ್ ಮುಂದೆ ಹೇಳಿ.
ಇಲ್ಲ ಇದು
leave it to your lordship.
ಪ್ರೊಸೀಜರಲ್ ಅಷ್ಟೇ ತಾನೆ.
ಪ್ರೊಸೀಜರ್ ಅಷ್ಟೇ ಅಲ್ಲ, even on merits they did not have any case. Procedure lapse ಆಗಿರೋದು, what would be the impact on it? I will place out.
No, if they have not been given a chance to adduce evidence.
Adduce evidence ಮಾಡಿದ್ದಾರೆ. All of them have done the evidence.
ವಿಚಾರಣೆಗೆ ಅಂದ್ರೆ ಏನರ್ಥ?
What they are trying to say is that further cross examination ಚಾನ್ಸ್ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಂತ. 2-3 ದಿವಸ cross examination ಮಾಡಿದ ನಂತರ then they file an application for spot inspection. What would be the impact of that is what tomorrow.
But tomorrow, but prima facie, I think.
I'll submit, my lord.
Number 64, shaving under.
OPS for the government. 64. He has to argue, isn't it? He is required to argue. ಮಾಡ್ತಾರ ಇಲ್ವಾ ಇವರು? Because basically they have to justify as to whether they can permit the levy of a tax through a bylaw.
If the act itself provides for making use of the bylaw, as section 199 says. In fact, earlier.
199 is the charging provision.
Yes.
It permits a Gram Panchayat to levy a tax. The maximum rate is prescribed.
Yes.
Now, if you had imposed a tax subject to being within the limitation of Schedule 4, that is one thing. But the bylaw can only be a piece of delicate legislation.
Correct.
They cannot determine the rate of taxation. They can amend Schedule 4 and say that this is the rate which you could have claimed. Without amending Schedule 4, you have a separate bylaw which contains.
So kindly look into section 199 earlier to the amendment.
section 199 as was existing prior to 2015.
Yes. ಸಿ ಒಂದು ಅಷ್ಟೇ ತಾನೇ ಇರೋದು. ಸಿ ಒಂದಿತ್ತು ಅಷ್ಟೇ.
ಅದೇ ಅದಕ್ಕಿಂತ ಮುಂಚಿತವಾಗಿ section 199 subsection 3 the Gram Panchayat may also levy all or any of the following taxes and fees at such rates as the Gram Panchayat may by bylaws determine but not exceeding the maximum specified in schedule 4.
Yes.
Schedule 4 provided for the rate at which it could be levied.
A Gram Panchayat may also levy all or any of the
Following taxes and fees
and fee at such rates as the Gram Panchayat may
by bylaw determine.
but not exceeding the maximum specified in schedule 4.
Supposing I have not adopted any bylaw at all or not made any bylaw, I can still rely upon schedule 4.
This is the outer limit.
Yes, outer limit.
You
Yes.
may bylaw, you may frame a bylaw. If you frame a bylaw, you may levy that tax.
Correct.
But even then,
It should not
shall-
exceed the rate specified in schedule 4.
so this power was available to the Gram Panchayat if it had decided to levy a tax.
Yes.
If suppose the Gram Panchayat was not able to go beyond the limits specified in the post schedule, can the government by framing a model bylaw have a larger amount prescribed?
Now, if we read in conjunction with the bylaw along with section 199.
No, your only argument is bylaw.
Yes.
Bylaw empowers you. But I don't know whether the bylaw can empower the government to go beyond the limitations that it prescribed for
Of
you.
course, bylaw cannot go beyond the provisions of the act. If it is only a creature of.
All it could have
enactment.
done was it could have amended the fourth schedule. Then automatically your demand would have come within that purview. But if it's not there, whether under the rules you can,
Now kindly see section 1.
My lords, I appear for the petitioner.
okay.
I apologize, my lords. We are led by senior counsel in this matter. He's on his legs, my lords. I seek a passover.
I have nothing to pass over. Let us hear him.
Subsection 3, I will read once again.
Yes.
Grama Panchayat may also levy all or any of the following taxes and fees at such rates as the Gram Panchayat may by bylaws determine but not exceeding the maximum specified in schedule 4. So schedule 4 makes the outer limit.
Yes.
I cannot go beyond that.
You can have it lesser than that by your own
Yes.
bylaws.
Yes, by bylaw, I
But
can make a provision for levying of lesser rate.
so the charging provision prescribes a maximum rate.
That is what has been specified in schedule
And that
4.
is for the Gram Panchayat.
Yes.
Can the government have the power to levy a tax on the basis of a bylaw?
Government has not levied any.
It has fixed a schedule.
It has fixed, even then, if we read in
Then-
conjunction with subsection 3 of section 199.
That's why I said, if they had modified the schedule 4, you're right. But the government can't impose a tax by framing a model bylaw. See, even, let's assume that you don't have a model bylaw, the government has done a model bylaw.
Right.
They have done your work and that you are bound by it.
Yes.
Even if they had done that, even that model bylaw will be subject to schedule 4.
It will always, it should
So,
always be.
Once it exceeds schedule 4, then there's nothing that you can do.
If schedule 4 specifies the rate at which I can levy,
That is our maximum.
that is. That's
But
what
that
I'm
is not,
saying.
no, you are claiming under the model bylaws, which has a much larger sum. Under the fourth schedule, it's only rupees 5 per square meter per month, and here you are claiming much more, depending on the size of the holding. Let us see what Banu has to say, because Banu has to
I have to
defend-
get some instructions. What my lord says, may I stand here, my lords?
Yeah, please.
What my lords have indicated is what I also found out. But they are now trying to draw powers which is conferred under 316 and 311 of the Panchayat Raj Act to say that they have powers to come out with this model bylaw, even though the rate exceeds what is scheduled, what is
Sir,
stated.
You're right that you have the right to frame a bylaw.
Please, my lords.
Model bylaw, it binds them also.
Please, my lords.
But the model bylaws will be subject to this 199(3).
Yes, my lords,
Which
you
is-
cannot go beyond that.
Now it is
ಸ್ವಲ್ಪ
much-
ಟೈಮ್ ಬೇಕು. I'll have to get some instructions, my lords. I've asked them. ಮೊನ್ನೆ ಇತ್ತು 27th ಇದ್ದದ್ದು ನನಗೆ ಹೇಳಿದ್ದು ಇವತ್ತು ಬೆಳಗ್ಗೆ. It was not
indicated to me anytime earlier. ನಾಳೆಗೆ ಅಥವಾ ನಾಡಿದ್ದಕ್ಕೆ ಹಾಕೊಂಡ್ರು.
I heard the arguments on the basis that they did not challenge the model bylaws.
Yes, Lord.
Therefore, I was against it,
Please, Lord.
saying that so long as you are not challenging the model bylaws, you are bound by whatever is stated in the bylaws. Then he pointed out that he is challenging the model bylaws also, saying that under the bylaws, you have no power of taxation.
True, Lord.
Bylaw can't be a charging provision.
Correct.
So other ಮೇಲೆ ಅಲ್ಲಿಗೆ ಬಂದು-
ನಂಗೊಂದು 2 ದಿವಸ ಟೈಮ್ ಕೊಟ್ರೆ I'll get some instructions. Maybe Wednesday, if my lords have it, my lords, at 4:30 again, please.
Please, great. Your lordships are keeping it day after tomorrow, Lord?
Yes, day after tomorrow.
Please, great, very great, very great.
ಒಂದು 3 ಮ್ಯಾಟರ್ ಇದೆ ಚೇಂಬರ್ಗೆ ಫೈಲ್ ಬಂದ್ಮೇಲೆ ಅಲ್ಲಿಗೆ ಬನ್ನಿ ಬನ್ನಿ ಇದೇ ಮ್ಯಾಟರ್ ಮತ್ತೆ ಮುಗೀತು ಎಲ್ಲ ಇನ್ನು ಬಂದಿಲ್ಲ ಫೈಲ್ ಅವಾಗಲೇ ಹೇಳಿದ್ದೆ ಇದೇ ಮ್ಯಾಟರ್ ಇದೆ ಬೇಗ ಮಾಡ್ತೀನಿ ಇಲ್ಲ ಕಡಿಮೆ ಆಯ್ತು ಫಸ್ಟ್ ಟೈಮ್ ಎಲೆಕ್ಟ್ರಿಕ್ ಇದಾಗಿದೆ